between here and San Francisco.
Okay, that's helpful.
I'm on the way.
We're in Minnesota, so it's a nice, really
Weather's
nice
good.
area. Yeah, weather's good. We'll take
It was
it.
rainy last week,
I know,
which was
that's what I
good.
heard.
Very good. We
Yeah.
need the rain.
We have rain now in Minnesota, so.
Okay, everybody, if we can try to take seats, I think we're looking to get moving soon. Hey. Perfect. Well, look, welcome. Thanks for coming out. It's fantastic to see people in the flesh, and we've got colleagues of mine traveling in from Germany, friends of ours in from Minnesota, and a mix of all of you friends and colleagues and clients of both of our firms. So welcome. I am Mark Webber. I am the managing partner of Fieldfisher's US business, and I'd actually with an office in the Bay Area here in Palo Alto. So we have a team of 14 UK and European lawyers killing time zone for West Coast business when they have UK and European issues. And here really to welcome everyone today to today's event. Mark Gardner of Gardner Law will come up and give you a bit more of an introduction about what's taking place for today and who's speaking and what we're going to introduce you to. But Fieldfisher itself is a European-focused law firm, originated in the UK, and really my part of the business is just loves the way we have to understand different types of law. We've got some common expertise in this room, but doing very different things, and the way the US would do something or the way a US state will do something can be very different to the UK or the European approach. And I have to say UK or European approach these days, down to some bad decisions by my fellow country people, so thanks to Brexit. But understanding those and helping guide businesses and our clients and those that we work with through those differences is an art, and something we really enjoy doing. So hopefully this session and the talks today will give you some ideas of how to navigate some of those differences. In the Bay Area, we see so much innovation, so much creativity, and just talking to a couple of people, just as we've been gathering now, just seeing how different people's journeys have gone from patent to litigation to then doing some data, and then realizing how technology, the confidential information, the IP, the data all being brought together, but then bashing into regulation and then having to navigate that regulation and understand it for the good of the businesses we work for, and to understand and overcome those regulations is everything. So some perspective there from you all. Fieldfisher, it's great to be part of this with Gardner Law and to bring this relationship together as well. And for those of you who don't know Fieldfisher as well, I should just sort of explain a little bit about us. We are a European law firm of around 750 lawyers, just over 1,000 people, and operating in 11 countries in Europe across 22 offices, I think it is. The West Coast office of mine is the only US footprint and doesn't do or practice any US law, but we're very much around bringing legal solutions together for clients in Europe. So we'll give you a bit of that perspective. Mark would introduce his own firm and his own colleagues, and look forward to talking to you in the breaks. Hope you enjoy these sessions, and I'll welcome everyone here in this room and everyone who's connected in. And I know we've got well over 100 people listening in to these rooms, but it's a beautiful day here in the Bay Area, and welcome everyone online as well. So Mark Gardner, I'll hand over to you.
Thank you, Mark. Well, it's really fun to be here and see lots of familiar faces that I've been talking to over the phone or on Skype or whatever it may be for the last couple of years. So it's finally come to fruition. Cord and I have been talking about this meeting in Oliver for a couple, 3 years or so. So it's really fun to be here. I'm going to start off with a little bit of take you on a little history lesson just for fun. And it's really born from this MedTech industry, this pharma industry that we are all contributing to and get up every morning to work in. We're doing something that I really do believe helps humanity. Even though we're the lawyers or the regulatory folks or whatever, trying to keep the people out of trouble that are ultimately inventing things and bringing them to market, that's our job, right? But it is an important one because it protects the public and ultimately makes our clients successful. So if you think about Florence, Italy in the 15th century, that was where the Renaissance arguably began. There's some comparisons that have been made by historians about how Florence is like Silicon Valley. And maybe some of you have read an article. I read one a couple years ago and started to do a little research this morning to find out if that was true. And I really do think it's true. So if you look at the Florence, Italy in the 1500s, you had like the Medici family who were walking down the street one day and saw this 14-year-old sculpting, and it turned out to be Michelangelo. But they basically invested in him, became one of the most prolific artists in the world. Another is Da Vinci, that the Medici family invested in. And he came up with things like theorized the helicopter, the parachute, tectonic plate movement, solar power, the adding machine, things like this. I feel like a lot of those similarities are true here in Silicon Valley, where you have big ideas. You have people like Bill Hewlett, who essentially created computer. He and his partners brought forth computing machines, which he received a call one day from a 12-year-old Steve Jobs asking for some parts. He just looked them up in the phone book, and Bill gave him those parts and offered him an internship. So like Silicon Valley, Florence was also a merchant class where people mentored one another, and I think that's very true here in the Valley. There's other things, like there's a federal bank in San Francisco last time I checked, and there's a lot of venture capital money here. And in Florence, Italy, you had these families that were there to invest. They expected a return, but with that investment came a lot of great things. And lastly, there was a lot of cultural, artistic, architectural advancements during the Renaissance, as we all know. And California is oftentimes on the cutting edge of pushing policy and things like that. So I think there are indeed a lot of similarities between Florence and Silicon Valley. So it's exciting time to be alive and to be part of that movement, if you will. And I know that you are all part of that movement. So with that, I'll talk a little bit about the agenda. And if we want to go to that slide, I can just walk through it. I know it by heart. First, we're going to have Amanda talk about the park doctrine. And I don't want to steal her thunder, so she's going to ask you if you know what that is. If you don't, prepare to be scared. We're here to bring good news to the world every day. That's our job. Then Cord is going to talk about some things that are occurring in Europe from a healthcare compliance standpoint. I know that we rely on Cord and his team and Oliver regularly for help for our clients. And I want to mention David's in the room here, and David introduced us some years back when I could not find a GDPR lawyer to save me from all my clients. Getting a call every week, we need help with GDPR. Finally, David said we should call Cord, and it was a great partnership ever since. So Cord's going to cover that. Then I'm going to talk about things you can say before your product is approved. I don't know, I feel like we're in a time right now where there's just a ton of products that are coming to market, and I think that's probably a result of all the investment that's occurred recently. But we get that question almost daily, what can we say? And I'll get a press release from a client, and it'll have a lot of claims in it, and I say we got to be careful. So I won't start my presentation now on that, but we'll talk about clinical trial recruitment, a few slides on that. Then Oliver will talk about Schrems 2, an important case in Europe that relates to privacy and some other updates. And then Paul will talk about cybersecurity, which is a very hot topic. Paul will get into that and give a quick update on US privacy as well. And then we have a panel of distinguished Valley GCs that will talk about some of these topics that we're covering today, and Amanda will moderate that panel. So I think that's it. So some housekeeping. We're going to record everything today, so you'll have access to everything after the meeting. And if you have questions, please, I encourage you to raise them so that we can have a dialogue. I think that's one of the most exciting things if we all get together. chances are if you have a question, the audience is also thinking the same thing. But let's make sure we capture that question. So Amanda or Paul will be watching the audience for questions, and you'll get the microphone. And if you're online, we're also monitoring questions online. And I think we have over 100 people online, if I remember correctly. And I think that's it. So I'll now hand it over to Amanda for an uplifting conversation about how you can be criminally liable for your employees and their actions, even if you don't know about them.
Am I live? Yes. Should have worn heels today. Realized that when I came up here, but that's okay. Good afternoon, everyone. Thanks, Mark and Mark, for the lovely introduction. I echo their comments. It's great to see everybody in person, and everybody online as well. So, all right. Well, Mark kind of alluded to the topic that I'm speaking about today, but we're going to talk about the park doctrine. I don't think it gets enough attention. I don't think it gets kind of the lip service that it deserves. So we're going to go into detail on that today. Just quickly, my name is Amanda Johnson. I'm a managing attorney at Gardner Law. I've been with the firm for about 3 years, and prior to practicing there, I've been in-house in various compliance and regulatory roles at medical device companies. I also teach drug and device law with Mark and one of our other colleagues. We teach drug and device law. So yeah, I split my practice at Gardner between regulatory strategy submission work as well as compliance, anti-fraud, compliance program type stuff. All right. So we're going to talk about FDA violations, enforcement mechanisms. We're going to mostly focus on the park doctrine and how it's been used. We're going to look a little bit at the DOJ's perspective, because obviously that's a piece of the puzzle as well. We'll do some predicting on, what we'll see from a park doctrine front in the coming future, and then some just recommendations and parting thoughts. And as Mark noted, if anybody has questions, raise your hand. We'll run a microphone to you, and then if you have questions online, we'll monitor those as well. All right, just to ground everybody, I think everybody knows what the Federal Food, Drug, and Cosmetic Act is, but this is the body of law that we're working under. So it was passed in 1938, giving authority to the FDA to essentially oversee the safety of food, drugs, and cosmetics, and medical devices were later added, as well as other categories. The key point is that FDA then implemented regulations, and those regulations dictate how drugs and devices are manufactured and promoted. So there's lots of rules, as I'm sure you all are very familiar with. It's also important to remember that FDA is not a law enforcement agency. They are responsible for protecting the public health. That's their mandate. So they work closely with some of the other law enforcement agencies, but their mission is to protect public health. All right, so we have, the Food, Drug, and Cosmetic Act. We have the FDA regulations. What happens if those FDA regulations are not followed? So there's two primary prohibited acts under the statute: misbranding and adulteration. Just at a high level, of misbranding typically means that something's wrong with the words used to describe or promote the device. So some examples of this would be promoting for unapproved devices, or promoting unapproved uses or features, making false or misleading statements about a product, or not balancing benefits with risks, inadequate directions for use. Adulteration, on the other hand, is more to do with how the device is manufactured, how the product is manufactured. So it could be a rat infestation at a warehouse. It could be a company that has an inadequate quality management system. There could be other manufacturing issues. So just at a high level, these are the two kind of buckets that FDA violations will fall under. So the first one is kind of the words and discussions around a product, and the second one is more around how it's made. All right, we have a poll question. And those of you online, I think there's a poll section that will pop up. So if you could navigate to that. And those in the room, I'll just have you raise your hand. True or false? As an executive, you can be held criminally liable for your employees' misconduct even if you don't know about the misconduct. Who thinks that's true? Anyone false? Mark gave away, he stole my thunder. Do we have any results online?
Online, there's a 94% agreement that it's true.
Okay, good. Well, that's good. I'm glad that we are all at least aware. All right, so now we'll segue into the park doctrine. So this actually, this whole concept of holding corporate officers liable for acts of the company and their staff actually began back in 1943. The case was US v. Doderweich, I think is that how German colleagues, is that how you say it? I think so. Doderweich. So anyway, Joseph, the president and CEO of a pharmaceutical company. The company essentially had like a private label. They would buy drugs, relabel them. In some of the cases, the labels were incorrect, so they contained either the wrong meds or the wrong amount or the wrong potency. There was an FDA violation, and Doderweich had no knowledge that the drugs that were mislabeled were actually shipped into interstate commerce. And so this went up to the Supreme Court, ended up holding that individuals can be held criminally liable for FDA violation without consciousness of some wrongdoing if they have a responsible relationship to or have a responsible share in the violations. So this was really the kind of landmark case where the concept of a corporate officer being held criminally liable came into play. And we'll look at the statute that they were interpreting. But essentially, responsibility and authority. So they will hold you criminally liable if you have responsibility and authority either to prevent in the first instance or to promptly correct the violation complained of, and if you fail to do so. So this was actually the first case, 1943. And then Park, US v. Park, wasn't until 1975. So Mr. Park was president and CEO of Acme Markets. It was a big national retail food chain. They had 36,000 employees, almost 1,000 locations, so it was a big company. There was an FDA inspection at one of the warehouses. They discovered a rat infestation. It's kind of gross. Acme actually failed to address the problem. So Mr. Park knew of the rat infestation. He delegated responsibility to address the problem down to his direct reports, but the problem was never addressed. So FDA came back, I think 2 more times, inspected, there were still rats. So they were actually Acme, so the company and Mr. Park were both charged with for putting adulterated food into interstate commerce. So again, we're talking about not the labeling, but the manufacturing issues. Acme pled guilty. Park ended up going to trial because he was saying, that's ridiculous. Obviously, I just run the company. I wasn't at the warehouse, that kind of thing. So the Supreme Court ended up saying that Park was properly prosecuted and convicted for the adulteration charge because the Food, Drug, and Cosmetic Act imposes a duty to seek out and remedy violations and a duty to implement measures to prevent violations on responsible corporate officers. So this again, we call it the Park Doctrine, but again, this is kind of really the first time where it's becoming more of a precedent. Liability under the Food, Drug, Cosmetic Act does not require awareness of wrongdoing or conscious fraud. Individuals in positions of authority in businesses that affect the public health, which is key, are held to a strict and rigorous standard of accountability under the Food, Drug, and Cosmetic Act. All right, so strict vicarious criminal liability is kind of scary, honestly, to think about. There's only a few, I don't know if you guys remember from law school, there's only a few areas where this is even a legal doctrine. One of which is possession of wild animals. So if you possess a wild animal, you are strictly vicariously liable. FDCA violations is another. And I think the only other one is engaging in certain extremely hazardous activities, which I'm not sure what that is, but So it goes to show you how seriously, public health is taken. It's a very rare use of a doctrine to hold someone liable when they, had no knowledge. So the Park Doctrine, which it's called, or the Responsible Corporate Officer Doctrine, essentially imposes strict, vicarious criminal liability upon responsible corporate officers for misdemeanor FDCA violations. There's no proof of knowledge. You don't have to show negligence even, no intent. You don't need to be involved in it. You don't even need to know about it. The liability attaches just because of your role, or the responsible corporate officer's roles and responsibilities. Kind of crazy. So it's 21 U.S.C. 333A1 is the section of the statute that the court's interpreting here. As you can see, there's no intent, there's no knowledge, there's no involvement requirements. And these are misdemeanors, which is, so, it's not more than 1 year in prison, but that's per offense. So it can add up quickly, I can imagine, and fines as well. All right, so we'll go back to our poll question. Answer is true. All right, so the Park case was, back in the 70s. There was very little use of the Park Doctrine itself, kind of in the last 50 years. I'm gonna go over some of the cases since 2007. There's really only been, I think, 16 or 20 cases, and there's some controversy over whether a case is purely a Park Doctrine case or not. But I'll just talk a little bit to give you an idea of kind of how this has evolved. I'll share some cases. So Purdue Pharma. So this one is still in the news. You guys have all probably heard of it, but OxyContin, they were allegedly making misleading and false messages regarding OxyContin, about how it's less addictive, less subject to abuse and diversion, less likely to cause withdrawal. In 2007, so the CEO, the general counsel, and the chief medical officer pled guilty to misdemeanor misbranding violations related to those false statements. In this case, these three executives, there was no evidence that they were involved in or even knew about the misconduct. So they were charged purely under the Park Doctrine based on the fact that they were in a position of control at the time the misconduct occurred. Synthes, this is another kind of popular one that I think a lot of people have heard of. So they had a bone cement product. Allegations were related to off-label promotion and making false statements. In 2009, so the president, the senior vice president, and the director of Reg Affairs and Clin Affairs, which is interesting, pled guilty to misbranding and adulteration misdemeanors. So in this case, the government did present evidence that they knew about and participated in the misconduct. So that's kind of where I'm saying they're a little controversial in that, well, it's not really a Park Doctrine case if they knew about it or participated in it. But I'm still including some of these just to give additional context. I thought that was interesting with the director of Reg Affairs. All right, in 2011, KV Pharmaceuticals. So this was a drug company that had some manufacturing issues that resulted in super potent, oversized morphine pills, which seems like a bad, bad issue to have. In 2011, so the CEO was convicted of a misdemeanor misbranding case or charge. In this case, the CEO did not know about it, but the court held that he had the authority and responsibility to prevent and correct FDCA violations. So in this case, he had no clue that they were making giant morphine pills, but yet he's criminally liable. Apothecure, so this is a US v. Osborne case in 2012. So this is a compounding pharmacy. Osborne was the president, director, pharmacist. I think it was a pretty small shop. They again had issues with potency and were selling inconsistent potency products, resulting in 3 deaths. In 2012, he was convicted of misdemeanor misbranding. Again, in this case, Osborne had no knowledge about the issue, but he was responsible for procedures, equipment, and training of employees, and had an obligation to essentially prevent the misbranding, is what the court said. So 2 cases where there was, literally no knowledge, just purely they should have probably done more, is kind of what the court said, based on their position of authority. All right, then we have a couple food cases. Jensen Farms. So in 2013, so this is actually the listeria outbreak with cantaloupe. I still remember this, actually. 2 principals were convicted of a misdemeanor adulteration, so now we're talking about manufacturing issues, based on knowledge of conditions that resulted in contaminated cantaloupe, and there were 33 deaths. So the 2 principals did not know that the cantaloupe was contaminated when it went into interstate commerce, but they did know that they hadn't implemented sufficient procedures around anti-contamination to prevent it. So it's just interesting. Egg case, so salmonella contaminated eggs. This is Quality Egg LLC. So in 2014, executives were convicted of misdemeanor adulteration. Again, in this case, they did not know the eggs were contaminated, but they knew of certain sanitation issues and did not address them. And one of the more recent ones is Indivior. They had a Suboxone film that was used for the treatment of opioid addiction. Some allegations involved misleading claims, encouraging prescriptions that were not clinically warranted. In October 2020, the former CEO was convicted of misdemeanor misbranding based on his role as a corporate executive because he failed to prevent or correct FDCA violations. So again, strict liability, didn't know of it, wasn't involved in the misconduct, but was held liable under the RCO doctrine or the Park Doctrine. So kind of scary to see some of these cases. What does it mean today for responsible corporate officers? So this isn't really news. This has been how it is all along, but I wanted to take a moment today and talk about kind of what that looks like for the future and kind of where we are in the environment from an enforcement perspective. So it means that as responsible corporate officers, we have following duties. I mean, there's multiple there's a proactive, so we have a duty to seek out and remedy potential violations, and we have a duty to implement measures that will prevent them. So not only do we have to look for and fix things, we have to actually foresee issues and take proactive steps to prevent that from happening. And as depending on how large the company is, I mean, that can be really challenging if you're, it's a big company and there's a lot of layers of management. So yeah, just some examples of some things that could rise to the level of RCO liability. So we'll talk about a lot of these later today. Off-label, pre-approval promotion, inadequate instructions for use, product defects, quality issues, manufacturing issues. All right, and we can't talk about holding individuals accountable without talking about the DOJ. Of course, FDA, as I mentioned, their mission is to protect the public health. They're not a law enforcement agency. They're not bringing these cases alone. So we also want to explore the DOJ's perspective because they obviously work with OIG and FDA when they're prosecuting cases. So just quickly, kind of a summary of the recent history on individual accountability from a DOJ perspective. I'm sure you guys all remember when the Yates memo came out. It was a very hot topic. Essentially, it focused really on individual accountability for corporate wrongdoing. I like this quote: "One of the most effective ways to combat corporate misconduct is by seeking accountability from the individuals who perpetrated the wrongdoing." So here we're talking, in 2015, they're kind of talking more about individuals who perpetrated, so individual accountability. And in October 2021, they issued a memo where they created a corporate crime advisory group within the DOJ. And in September 2022, so just recently, they came out with, an update based on the feedback from that group. And again, affirmed really focus on individual and corporate accountability. So the department's first priority in corporate criminal matters is to hold accountable the individuals who commit and profit from corporate crime. So they're clearly looking at individual accountability, and they've made that clear now in the most recent DOJ memo. So predictions. So will we see more of park RCO enforcement? This is just my prediction. I think we probably will. I think it will be particularly in cases where patients are dead. We have deaths, harm, defective products, egregious, false, misleading messaging. If the company has quality management system problems, a pattern of issues that haven't been addressed, and if the company's compliance program is really ineffective or insufficient. There was a recent editorial in the Journal of American, or the JAMA publication in September 2022. And I don't know if you guys have read it. You should Google it if you have not. I don't know if it's under a paywall. Essentially, it's a few authors that are arguing for increased use of the park doctrine, basically because that will promote the doctrine's goal of protecting patients. Basically saying the government is not using it enough and we need to use it to sanction and deter bad acts. So this, together with the DOJ's recent affirmation on focusing on individual accountability and kind of the trickling of park doctrine cases we've seen, I do think we probably will see more. We'll see. We'll have to keep an eye out. I will note that we've seen, last summer, July 2021, the OIG released 3 press releases outlining settlements related to device quality issues. And I think it's interesting because these, to my knowledge, they haven't convicted any of the corporate officers, but they're all related to quality issues, defects, and in each case, there was patient harm. So Alere, in July 2021, they settled almost $40 million under the False Claims Act. The allegations were that they knowingly sold defective blood coagulation monitors that produced inaccurate and unreliable results for some patients due to algorithm defect. To my knowledge, I don't think any of the executives have been charged. It's unclear why. FDA does have a list of factors that they consider, which it's not like rocket science because it aligns with every other criminal, kind of the burden of proof for criminal prosecutions, but perhaps, there's more going on, and I don't know. I'm speculating as to why they wouldn't have gone after executives here, but I think it's interesting. St. Jude, there's a $27 million False Claims Act settlement. This is again related to defective products. This one, there was a recall, and they essentially just said that they failed to disclose it to FDA. They failed to fix it, and it was an issue that resulted in device failure. This one was brought by a patient, which is interesting. Again, to my knowledge, I don't think any of the St. Jude executives have been criminally convicted under park doctrine, and I haven't heard of any. Who knows? Maybe it's ongoing. I don't know. Avanos Medical, another one. This one is a little different. It's a criminal misbranding case against the company. They also entered into a deferred prosecution agreement. This one was a little bit more, they actually made false statements to FDA, and they had surgical gowns that were labeled incorrectly, intentionally, it sounded like, allegedly, I should say, with a different protection level than what they actually were. So this is just to remind us that, device quality issues can end up in an OIG settlement, and that together with some of the park doctrine, considerations, just kind of will dovetail into the best practices, but just thinking about kind of things that we could do, or, you know, it's hard to prevent a strict vicarious liability criminal charge, but there's some things that we can think about and be proactive about, and just kind of be mindful of as we are, you know, hiring and forming companies and starting companies. First of all, I think a compliant and operational quality management system is really essential. I mean, that has to be a top priority. Investing in quality is not something you should skimp on. Conducting internal audits and monitoring is a good idea. Also thinking about the compliance program. So from a healthcare compliance program perspective, maybe consider leadership training on the park doctrine, just so people are, you know, there's awareness. You know, we all know about it, maybe not everybody. Consistently enforcing compliance program violations, so being clear about expectations, and really working on instilling and perpetuating a culture of compliance is probably the best thing to do, although it's you know, it's harder than it sounds, because you can't really just one day have a culture of compliance. But really kind of embedding that into the company's culture, encouraging raising of concerns and questions. These are kind of things that at least could help mitigate the threat. Making good hiring and promotion decisions. So it sounds easy, another one that sounds easy, but it is something to think about when you know, you're creating a company, or, you know, making changes in your management team. Establishing clear expectations related to supervisory responsibilities. So in the Park case, you know, Mr. Park delegated to his staff to take care of the rat problem, and it didn't get done. You know, if you're going to delegate tasks, especially ones that relate to product defects and quality system, have a system, making sure it's done, you know, kind of double checking, triple checking, that kind of thing. These are just good practices in general, but might be more beneficial here. Be proactive in identifying and addressing issues, quality, marketing, you know, make sure there's policies and procedures and training in place to make sure that marketing messages, for example, are being vetted and are being used properly. All right. Is that depressing? Does anybody have questions? Do we have any online? Paul, can you get the mic? There's a couple in here.
Hi. Good presentation. Thank you. To remind everybody, I'm curious about the definition of responsible corporate officer.
Yeah.
What is a legal definition of corporate officer?
Yeah. No, that's a really good question, because I looked into that as well when I was creating slides, and I was trying not to go down a rabbit hole. There's not like a specific case that talks about it particularly, but they look at kind of the scope of responsibility. So it's not tied to a title. It's definitely not tied to a title. It is more, do they have authority and responsibility, and did they have authority and responsibility to take the action that they should have taken? So I don't have a definition for you, but it's squishy. But yeah, it's definitely not based on title. So. Oh, okay. See, we all had the same question. Yeah, I know. Maybe they need some cats. That's probably adulterated too. All right. Well, good. Well, thank you very much. If there's no further questions, I will turn it over to Cord.
Amanda, thank you very much. So, meine sehr verehrten Damen und Herren, ich freue mich sehr, Sie jetzt auf die andere Seite des Atlantiks zu entführen. No worries, that were the last German words that you hear from me in the next 30 minutes. I just wanted to raise the attention. I now have the pleasure to give you an update on EU healthcare compliance. So, and you will see that we also have kind of case law that is similar to the Park Doctrine, but I tried to make it less dramatic as you did. A brief view on the agenda. I will start by updating you on an EU level. Most of you will know that we don't have such an EU healthcare law, or we have a harmonized standard when it comes to the cooperation or interactions with healthcare professionals and healthcare organizations. So internationally active companies might face a challenging situation when you have a kind of business activity or you have the intention to do an interaction with healthcare professionals from several member states, that you face different legal requirements, different legal regimes. This is a bad message, but nevertheless, there are solutions for it, practical solutions. And I've just said that we don't have a harmonized standard. This changed recently, last year, because the MDR, now also the EU medical device regulation, which we will also cover a bit later this afternoon, is now giving guidance about the product-related advertisement. So this is quite interesting, I believe. Very happy to update you there. And I said we don't have harmonized standard, so we have to do a country-by-country analysis, and I'm very happy to give you an update on the key markets where we have recently seen some new trends, some new legislation, some new case law. And this, in this case, these days, covers in particular Germany, Italy, the Netherlands, and France. So, starting with the EU healthcare compliance regime. As I just said, there is not such an EU law where you can just have to look up and then you see all the legal requirements that you need to know for any kind of interaction with healthcare organizations, healthcare professionals, patient organizations, or patients. So, the bad news is, or the bad message is, you can face 27 different legal requirements in the different member states. So this is a challenging situation, and we don't face such a challenging situation in other legal regimes. So when it comes to the already mentioned EU medical device regulation, which applies since May last year, we can say that when it comes to manufacturing, legally placing medical devices on the market, clinical investigations, labeling, packaging, then you have a fully harmonized standard. Only courts in the national member states can have a different interpretation of a legal requirement, but it's a regulation, so it's directly applicable. The same applies to GDPR. It's also a regulation, and Oliver will tell you a bit later about this afternoon. That was the bad or the negative message that I have to give on an EU level, but nevertheless, you have principles, major principles about this cooperation with healthcare organizations and healthcare professionals. This is a principle of transparency, separation, equivalence, and documentation. You all know this. When you engage with a healthcare professional, it's the principle of equivalence. You have to pay fair market value for the service rendered. Everything needs to be in writing. You have to obtain an employer consent if he or she is employed at a medical institution. So these are the general principles that apply EU-wide, and I believe also in the US, worldwide, I would say. So what you can do as a US company who is approaching the union market, which includes several member states, you can have a look at the MedTech Europe Code of Ethical Business Practice, because this is a very, very good summary of all the legal requirements that are applying in the other member states. And what you can also have as a very good legal reference is the compliance handbook. It's a country-by-country analysis from MedTech Europe, where specific or country-specific particularities exist in the respective countries. So when you want to achieve already, I would say, a reasonable level of legal certainty, if you are doing a multi-country cooperation with healthcare professionals, have a first look at the MedTech Europe Code of Ethical Business Practice, and then check in the compliance handbook, which is renewed and updated every second year from MedTech Europe, if there are country-specific requirements that you have to consider. So this is my advice. When you're seeing the situation, there is no harmonized standard, but use the two references, when you want to get a first impression, and when you want to get 100% legal certainty, then of course, reach out to local counsel. So this is how you can deal with the non-harmonized standard. We now, I've said or in theory, we have 27 different legal regimes applying to the cooperation with healthcare professionals. This does not apply anymore for product-related advertisement. Because quite surprisingly, because the EU medical device regulation is a regulatory law and normally only addresses what do I have to do to run through the conformity assessment procedure, what do I have to do if I put my technical documentation together, what do I do with my notified body in the cooperation, how do I have to manufacture, how do I have to produce and also label my medical devices. So in Article 7, you out of a sudden, we were all surprised, found rules about product-related advertisement for medical devices. And this Article 7, I copied it here and made a summary in bold letters. So what you can see in this Article 7, which applies now for 16 months, that you can see there are the general principle, of course, summarized, prohibition of misleading advertisement. This is nothing new. You all knew this. This applies worldwide. So in Article 7, subsection A and B, it's a summary of the prohibition of misleading advertisement. What is very new in Europe, and to my best knowledge in all the member states, that we are now required to also include mandatory information in product-related advertisement. So whenever you provide information that are of promotional character to patients or to healthcare professionals, you have to include or you have to inform the user or the patient of the likely risk that is associated when the medical device is used within its intended purpose. I think you're already familiar with this in the US, but this is new in Germany and all the other member states. So mandatory informations now also apply to product-related advertisement for medical devices. Still very unclear to us how this requirement will be interpreted, because what you can see, it shall be prohibited to fail to inform the user of the patient of a likely risk. So what does it mean? How should he be informed? Should the mandatory information be directly under the safety or efficacy claim, or is it sufficient that we are having a link to the company website where you can find the instructions for use? So this is all that will be clarified then later on by national courts. So this also gives you the opportunity include mandatory information, but you're still having a lot of room how to interpret this rule. There are no official guidance or case law who's narrowing this down, this legal requirement. We heard today already quite often about the prohibition of off-label advertisement. We didn't have anything like this in Europe unless last year. Of course, from a product liability standpoint, it was always recommended to never do this because you extend your liability when you do off-label advertisement as a manufacturer. But now, first since a year, we now have the legal prohibition of off-label advertisement. That was my update on an EU level. And now I'm very quickly running you through the country-by-country updates where we have seen in the recent past new trends, legislations, and guidance that I would like to inform you about. I'm informing you about a trend or something that is not happening in Germany, and I still believe it's very unusual. There is no German Sunshine Act. This is quite special because most of the member states, one after the other, now introducing Sunshine Acts. So it's required from a legal perspective, it's mandatory that any kind of transfer of value to healthcare organizations and professionals needs to be disclosed to an authority or on a public website. We don't have anything like this in Germany, despite the public opinion is really calling for it, and all the stakeholders in Germany are really willing that the legislator is implementing one. But it's still not happening. Another trend, what we have seen, a development, is about the principle of equivalence. So you know all this fair market value needs to be paid for service rendered by a healthcare professional. We had very old case law on which we could reasonably justify an hourly rate of 150 euros for a key opinion leader when providing highly qualified medical service. That might sound ridiculous from an US perspective, but that was common practice in Germany for several years. 4 or 5, 6 years ago, we have seen an increase, so it went up to 200. And what we have seen in the last months, an acceptance from medical institutions to go up to 250. And I see this acceptance from healthcare organizations that they already say for their employees you can pay them 250 euros as an indication that this will also be accepted by German courts as fair market value when you engage with a healthcare professional and he or she is providing qualified medical service. The same, we see an increase in the meal limit. So what is the price that you are allowed to pay when you invite a healthcare professional for a business lunch or dinner? It was over years, case law from 2008 was saying it is 60 euros. And now it's planned that the German MedTech Industry Association, BVMed, will issue an official, it's not a guidance, it's an official recommendation that the meal limit should now increase up to 75 euros. And Amanda is not in the room anymore, but we also have a park doctrine in Germany. But just recently, because we had case law from the higher regional court in Nuremberg from March 2022, so from this year, in which the court has said that it is one of the duties of the managing director of a GmbH to take care of the well-being of the company. And if there is a compliance infringement and there was no sophisticated quality management system, compliance management system, no code of conduct, no further guidance or monitoring for the employees, what they need to observe when they do interactions with healthcare professionals, then this managing director could be held personally liable from a civil perspective, not from a criminal perspective. Yes, please, Alain.
Does it matter if the parent organization is doing something versus the subsidiary and you have different people as the managing director of the subsidiary? Can you get around it somehow?
I mean, you have to be the managing director of the GmbH. Sorry. Alali, I'm afraid you have to repeat the question with the microphone.
You would rephrase it so much better. My question was around when you have an American parent corporation, but you have subsidiaries in Germany that may be limited to certain activities, if you can bifurcate the responsibilities to avoid this personal liability of the managing director.
I think the addressee of this law or the case law is the managing director of the GmbH. And there you would just have a look at the public register who is fulfilling this function. And when you have an infringement within the organization from one of your employees, then they would simply check was there a robust, solid, and working compliance management system? And if not, they would just go to the managing director. And you, of course, then would be held liable, so the mother company, by maybe other means, FCPA or what kind of laws you are having here in the US. Very. Okay, this is our park doctrine that we have in Germany since a few months, now for 6 months. And if you don't have any questions about the update on Germany, very happy to inform you about the fact that the sun is now also shining in Italy. I have said that Germany, as one of the last countries, is not having a Sunshine Act, but Italy has now one, and they have implemented it. Where can I see it? That was May 2022. And before that date, it was still not mandatory, so not on a legal basis. Companies were obliged to disclose the transfer of value to healthcare professionals. It was still self-regulatory, so it was only recommended by industry guidelines. And now we have an Italian Sunshine Act. But we are still somehow in a grace period or transitional period because the public or the Italian government still needs to establish this so-called Italian healthcare register where you then can fulfill your reporting duties on. And once this has been established from a technical perspective, then you have an additional 6 months that your reporting duties then apply. So just that you keep in mind, next year you will report something. So next year, meaning quarter 3 or quarter 4 in 2023, you will need to report any transfer of value to healthcare professionals and healthcare organizations if they are above the individual and organizational benchmarks that you see here on the slide. That's my update to Italy. Now we are coming to the Netherlands. It's not really an update, but this is something that I have seen in my practice, or I came across in my practice a few months ago, and I think it was a very nice idea to somehow not circumvent the prohibition or the recommendation of not doing direct sponsoring anymore. So you all know it's common practice, or it's a recommendation already in the US since years, and also in Europe, it's via the MedTech Europe Code of Ethical Business Practice, and also by the national industry guidelines. It is recommended, not prohibited, it's recommended to not do direct sponsoring anymore. So you do not sponsor the passive participation of a healthcare professional at a third-party organized educational event. So this is direct sponsoring. It's recommended to not do this anymore in Europe since 2018. Now it's done via educational grants. If you still want to educate your users or your prescribers about your technology, you can do an educational grant to the healthcare organization, which then selects the benefiting healthcare professional who is allowed to passively participate at this third-party organized event. But what I have seen in the Netherlands, or maybe one more information I would like to give to you, the market really calls for this direct sponsoring. At least our clients in Germany and in the EU, they are really saying, we have key opinion leaders, we need them at this medical congress. We need them to send, or we would like them to be at an US congress, and is there anyhow an option that we still do this direct sponsoring? And if, because our competitors is doing this, or is constantly doing this, so if we do not send them, we get a competitive disadvantage if we are not doing it. So what we are doing, we are issuing legal opinions where we're saying it's a recommendation from the industry. Maybe you're not even member of this industry association. German law is not prohibiting it. So it's not somehow not accepted. It's not industry standard anymore. But from a legal perspective, you're still allowed to do it. And having this in mind, that any industry association is saying you should not do this anymore, the market or the practice is asking for it. I found it very charming what I've seen in the Netherlands industry, or the GMH industry code of conduct. They have simply said you can still do it unless you do not reach certain limits or certain benchmark, or you're not exceeding certain limits and benchmarks. So it says if the company is not contributing more than 500 euro to a healthcare professional for this direct sponsoring, or not more than 1,500 per year, it's still okay, it's still acceptable. And what I've also seen is quite common. It's accepted when the healthcare professional is paying 50% of the expenses on his or her own. This is quite interesting, because then they do the model. We sponsor your participation, but you give a speech at this conference. You get a fee for it, and the fee covers the 50% of the expenses. So I think it's a quite charming, not trick, or a quite, I would say, a quite good approach to circumvent this recommendation to not do direct sponsoring anymore. So the last country update is France. We have a new law in France, or a new Charter, which is called the French Charter for the Presentation of Educational Information and Promotion of Medical Devices for Individual Use. It has been implemented in March 2022. The aim of this Charter is to have a better quality of the promotional and information that are given from a manufacturer to a healthcare professional. And there are two things that I want to draw your attention to. First is, companies must implement a quality management system for their presentational, informational, and promotional activity from March 2023 on. This is quite interesting because it's not only that you have to have a quality management system from a regulatory perspective that is checked and inspected by a notified body. No, you also need to have this now when you issue just information, not even of promotional character, when you issue information or promotional brochures to healthcare professionals. This is something I would like to draw your attention to. And then I found it very strict. It's also limited how much company-initiated visits a healthcare professional may have from your sales rep. So it's not allowed to have more than 4 per calendar year. And this is very French specific. I've never seen something else like this in other member states. But I'm not surprised because with the French Sunshine Act, the law Bertrand, they already have made very strict requirements for the reporting of transfer and value. And this just fits in the picture when it comes to healthcare compliance regime in France. So this was my last update, my last country-specific update. And I'm very happy to now hear your questions, if you might have any. Please, over there. Wait for the microphone, please. Paul, thank you.
For France, can you give an example what you mean by QMS, implementation of presentational information?
Sorry, say it again. If I have an example of providing information.
No, what does it mean to implement QMS for presentational information? You mean to have an SOP, or what specifically that activity?
For instance, but I would very much expect that it's an SOP. You must have a responsible person like Qualitätsbeauftragter a quality responsible person for also that checks the informations and the promotion that are issued to healthcare professionals. Maybe an SOP requires a check from the legal department, from the regulatory department. I would expect something like that. But the criteria are not yet set. That's why we are still in the transitional period. So you can obtain this certificate only from March 2023 on. You're welcome. Any other questions from the room or from the audience remotely?
Nothing remote.
Okay, thank you. Then I'm very happy to hand over. Mark, is it you taking over then? Please, the stage is yours. Thank you.
Thank you, Cord. The all-important clicker. Tracy's telling me to look at these slides because from the viewers online, it looks like you're looking off the PowerPoint presentation. So I'm going to look that way. If I do look that way at all. Yeah, sorry, Amanda. You were looking the wrong way the entire time. No worries. My name's Mark Gardner. I think I know just about everybody in the room, so it's a pleasure, as I mentioned earlier, to be here. I'm going to jump right into it. So what we're going to be, well, we start with a poll, actually, as long as Tracy gives me the nod. Are we ready, Tracy, online? So I'll say I'll ask the question. You guys can just show me by show of hand. Does your company have a product pending FDA approval? Show your hands. Raise them high for me so I can. I'm going to guess we got 40% of the people in the room have a product pending FDA approval. Do we have any online results yet? Paul, thanks.
About 58% of, so 30 plus online said yes.
30 plus? Okay, so pretty similar to the representation here. And if you don't have one, I could ask another question, but I assume like at some point, your company will have a new product coming out. So before I even get into all of this, what this is really about is this question, I probably get it once a week or so. maybe at least I'd say when it's busy, it could be once a week. It couldn't be any less than once a month. So I ended up writing an article. So if you want to go do something else for the next half hour, you can just read an article on our website on this topic, which I probably took 15 hours writing that article. I'm not even kidding. So, and you may be saying, Mark, aren't you in the business to, provide legal services and charge for it? But I am, but it is a great question that comes up a lot. So I'm trying to help you guys out. So really, the question that I'm raising here is your marketing person comes, like your company got really excited because let's say they're a really R&D company, but they're like, we're going to get FDA clearance, we're going to submit this 510K, this de novo, NDA, whatever it may be, on January 1st, and then that date goes by, and now it's June, and you've got this marketing person sitting there like, what can I talk about? I want to issue a press release that says how great this product is, and you, the lawyer, are like, well, you can't yet because it's not approved, and you're going to get in trouble, and according to Amanda, I'm going to get in trouble, so. But then the other side of that coin is, well, there are some things you can do. There's actually a ton of things you can do. And so you'll hopefully walk out of here with you can have that talk with your marketing person or your CEO more often than not and say, no, but you can't do that, but you can do this, which is always an enviable position as a lawyer. You can say no, but then you can quickly show how creative you are and keep your job, hopefully. So here's the statutory framework for unapproved products. So once in a while, I'll have an inventor come along as well, and they'll say, well, what can I say about this idea I have? I'm just trying to raise money. I don't have a product for the FDA. And if we wanted to get into a theoretical exercise, you could say, well, the product's not being introduced into interstate commerce. And so arguably there would be no legal violation if someone said, this clicker is going to cure cancer. I'm not a financial or securities lawyer, so I'm sure there's some of you in the room are, and there's probably some things you have to be careful about when you're raising money and the promises that you're going to make in order to raise that money. But let's get back into FDA land. So essentially the hierarchy or the framework for drugs and devices, and without me reading the slide, because I don't want to torture you, you can't create a new medical device and start selling it unless it's approved, or a drug. Okay, so I once had a case where this came up, where this plastic surgeon had made this great device for, he would buy these tubes, I don't know if anybody knows how liposuction works, but they go in and suck the fat out of you. And he was getting frustrated because the end of the tube was too rough. And you won't know who he is, so I'm not giving away any privileged information here. But he found a way to make it better. And it wouldn't harm the patient. Because when you're inside the body sucking that fat out, you can actually cause inflammation if the tube is not really polished well. And so he started making his own tubes in his practice. And he was really good at it. So some of his colleagues said, hey, we're under the same roof. Can you get me some of those tubes that you make? One thing leads to another, and he's shipping tubes all over, right? And then the FDA is like, hey, you're a medical device maker. And me as a lawyer, I'm like, no, we're not. He's in his practice of medicine, and these people are all under the same roof, and blah, blah, blah. And they're like, yeah, whatever. Get it cleared, and he did, and the FDA went away. But that's where this comes up. And you may be saying, well, Mark, he made a medical device for his own practice. Why is that lawful? Because you can. If you think of a pharmacist or a physician, they can compound drugs. The same is true for physicians with medical devices. They can make a device, and they don't for their patient in their practice of medicine, and they don't have to go to FDA to get that approved ahead of time. But let's just, for our purposes today, if you have a drug or a device, that does require, indeed, prior approval from the FDA. You need to get that prior approval. So if you were going to go out and sell emery boards, you're not going to have to go to the FDA and say, I need approval for my emery board. They're going to be like, that's a class 1 device. You don't have to worry about that. On the other hand, if you have a neurostim device or something like that, you probably have to go PMA route. So you might say, okay, well, Mark, what about investigational products? So the government needed to overcome this issue of introducing a device that's not approved under the Food, Drug, and Cosmetic Act. How do you do that with an investigational device? So they created, essentially a legal fiction and then codified it and said, it's okay if you get approval from us, the FDA, Congress said this, to ship this product into interstate commerce. So you have Part 812 and Part 312. So 312 is for drugs, Part 812 is for devices, and these are the investigational regulations. Importantly, at the bottom, so once you get this approval, you've got a brand new drug or device, you have to go to the FDA, get that approved ahead of time. If you have a drug or device that's already approved for something, and your doctor is using it for a new use, that you don't have to go and get approval for that again because it's already approved for something. The FDA will want you to get approval for that, and they'll want you to provide adequate instructions for use with the device, or it's misbranded, or the drug. But you can still ship it out there even if people are using it off-label. So I don't want to get too far off track here. The point with this slide is that you can ship these investigational products in interstate commerce, but importantly, we'll see how well that camera movement works. You can't promote or commercialize them. So that's right in the regulations. You can't promote an investigational product or as safe or effective. And you can't commercialize it. So, I mean, really from here on out, I'm gonna get off this train in a minute about what you can't do, and we're gonna start talking about what you can do. But that's a really important thing for you to walk out of the room with, is if you've got an investigational product, you can't promote it as safe or effective, and you can't commercialize it. And that can be kind of your like black letter law. So if your product manager comes at you with a press release and it says how great this new device is, and that there's a quote in there, and I'm kind of giving away a quiz question that comes up, but the physician said that it's a breakthrough and it's unbelievable. And that's what the physician said. I didn't write that. It's like, okay, A, you did write it, or you got the doctor to say it, and B, you don't get a pass because it's the doctor saying it. This is your press release, you own it. And if you're saying things like it's a breakthrough, that to me is an implied efficacy claim and or safety claim. You can't commercialize it either. So Amanda talked about the Synthes case earlier, and that was it was a rough case, right? If you're familiar with that one, if you've been in the industry long enough, you remember that once people died on the operating table. And once the discovery started, it turned out there were sales quotas attached to this investigational bone cement. And, it was, I actually ran into someone that was at Synthes at the time, and they were like, well, it kind of wasn't like that. You always get one side of the story in a lot of these cases, but people died. And it did turn out that there were sales quotas attached to this investigational device. That would be commercialization of a device, right? And that's one other kind of arcane point, is you're not supposed to be making profits on investigational devices anyways. So you shouldn't be commercializing them. Okay, moving on then. What are some other considerations? Once in a while I have a client that's like, okay, Mark, you just told me this 510K cleared device that I already have, that we just have a submission at the FDA. It's already cleared, so I checked that box. I don't have an IDE for it, so I'm not doing anything wrong there. What's wrong with my website that says things that this device can do that the FDA hasn't cleared yet? How am I violating the law? Well, FDA, and not to get into a First Amendment debate, right? We know how all those cases turned out. They may say, if I were the prosecutor at the FDA, I'd say your promotion of this device is misleading because we only cleared it for X, and you're talking about Y, which we're currently reviewing at CDRH. So you're violating this prohibition on making false misleading statements in any particular, which is a classic misbranding, part of the misbranding rules. So even though you don't have an investigational device exemption, Even though the device is already approved for something, you've got it in front of the FDA for review, and your speech is misleading, which misbrands the device because you're promoting a new unapproved use. Any questions up to this point? Okay. Quickly, what's the difference? Because this is now we're starting to pivot into what you can do. This could be kind of like playing a game here, semantics, but pre-approval communication versus pre-approval promotion. I'll use that with my clients and say, we're communicating about the device or drug when we have a first-in-human experience, or when we get interim data, or whatever it may be. We're communicating, but we're not promoting it. We're not saying that it's safe or effective yet. Okay, so those are the two kind of sides of the wall. And you can't go into part 812 and find out when you're or 312 for that matter, on the drug side, when you're going from one side to the other. So you just gotta, use your brain on that one and work with your team on, you have to analyze what they're doing and work with them on what they can say. So if they're saying things like your investigational product is better than what's out there, that's a comparative claim. They shouldn't be making that claim unless you have an IND or ID trial that's designed for clinical superiority. And even then, you'd have to be really careful with how you share those data. And obviously, if you're claiming it's safe, effective, economical, et cetera, those are all what I would consider claims that are promotional. And what are the different ways that promotion can manifest itself? Well, your marketers, I'm sure, have hundreds of, anytime they're awake, they're probably thinking of ways that they can promote products. So these are all the same, vehicles that you've all seen 100 times before. And there are some things here with a convention booth that's on there. We'll talk in a little bit, like, if you have a medical affairs booth, maybe there's something that you can do there to talk about your trial. Maybe you have a device that is up for clearance or approval. There's an FDA guidance that goes back to 1979 that we're still reciting. I think it was updated in 1981. Still a very old guidance. But that you may be able to take advantage of there in your convention booth. We'll talk about that in a minute. So backing up again, just to give you a little more ammunition perhaps if you're talking to that product manager. This is kind of Mark Gardner's perspective. You could disagree with me on this, but what are some issues with promoting before approval? And obviously the regulator says you can't, for all the reasons I just gave. That's not Mark Gardner's perspective, that is the regulators. But this business perspective is, you might ask your commercial function, your CEO, why do you want to sell this product that you can't ship? What's the purpose of that? Well, let's say, because we want to create demand for it, so when it is available, we can ship it. But I have to tell you, as someone who worked in commercial roles for a decade, been practicing law going on 14 years, I was in a position as a product manager at 2 companies and a sales rep at the first one out of college, where we did have products that were coming out. And when I tell this story sometimes to clients, when I was selling them, then the customer would say, well, call me back when that's available. I don't want to order anything. I want to order the next device that's even better than the one you have now. So salesperson loses in that case. So you may consider that selling something that is not approved is a fool's errand. In other words, a worthless task. Your marketing people probably will disagree with me, but that's my perspective. Question, Sandy? Yeah.
I was just going to add that's a very important point that you call out, because for today, a lot of products have follow-on indications. So a lot of commercial teams realize that even though it may not be available for a particular indication, if they start talking about it and create and generate enough buzz, the product is available on the market. But for other indications, and they have the leeway to use their expertise as a medical professional to prescribe how they want. So this is where companies, I always tell my companies, you don't want to be in a position to where you can't pass the test, and then now you have to defend your actions and your intent, because it's going to come down to intent, and it's going to come down to what you're disclosing and why. So that kind of goes back to the previous slide that you showed on pre-approval communication. So I always tell them, like, you're not going to find these things written out. But if you think about it, like you said, think about the medium and the communication of how you're communicating. You're publicly traded, so you have to disclose that you're studying. But if the intent comes through that you are actually trying to disclose that you're studying it so that people can pick it up and start using it that way, you will be put on the hook, because once you're caught by FDA or DOJ, even though a lot of people say we can defend it, you can, but you really don't have much that you can say once they start looking at you, because they'll go further and further to look at intent. And this is where internal communications and all the things that Amanda touched upon become a part of the case, and how companies do end up being held liable in the end.
Yeah, that's a great point. Yeah, you might have a device or drug that's already available and you're just getting a new use approved for it. And so they could actually use it for that new use now. In my own experience, we had products that were truly not available yet, and they were for new indications. So something to think about. You may push back on your business. Hey, I don't really understand this. Juice isn't worth the squeeze here. We're taking a lot of risk to pre-promote this product, and I'm not sure it's going to move the bottom line. We shouldn't be doing it anyways, but why are you doing this? So what can happen, and this is kind of, thank you, Sandy, this kind of parlays into a few slides that I have on here to terrorize all of the CEOs that you work for. But these are examples where CEOs got up. A lot of times they're trying to drive investment in their company, or perhaps have the stock reflect its what they would view as its current valuation. So they'll come out and talk about how products are great, how they're safe and effective before they're approved. And that happened with this CEO. This is a while back. This is Intermune, but it's an interesting case. So these are real world examples that you could bring up. Do we want to pre-promote that? Because if you remember Dr. Scott Harkinen of Intermune, he did that, and then he was in a press release, and then he was sentenced to 6 months of home confinement, and he has a criminal record now, and he was on 3 years probation. He also had to pay a fine. So all of that, except for the 6 months, we all just went through COVID, maybe 6 months of home confinement. It's probably not a big deal anymore. But the criminal record part is not a lot of fun. And essentially, I won't read all of this, but the government just said, hey, what you were telling people wasn't true, it was false. We had another CEO. I hate to pick on this guy, I don't know him, but this is kind of, if you've watched CNBC at all, this is what you see guys that go on there that are CEOs to kind of pump up their stock, right? So this CEO went on and did just that on, I think it was Fast Money. And, he was issued, the FDA said, hey, what you're saying isn't true. Here's a warning letter. Then the DO Justice issued a subpoena. They got involved. CEO gets fired. Company has to deal with cleaning all this up. So this, again, is another real-world example. So, okay, let me get on track here and talk about what you can do. So communications that are generally allowed before approval. So if you're communicating about your product in a truthful, non-misleading fashion, and you're not commercializing it, you're not promoting it, here's some rules and some considerations. If you're going to do that, you don't have branded promotion. So you don't have a promotional branding scheme for your investigational products. Certainly that one that doesn't look anything like existing products. So be mindful of colors, fonts, design elements, etc. Medical affairs staff should participate in scientific exchange, which we'll talk a little bit more about that in a minute, not your commercial staff. Use disclaimers, so disclose everywhere that it's investigational. If you're going to issue a press release, use that disclaimer that comes right from the CFR. And then audience, and this is a general, take a step back. What does your marketing person want to say? Consider the audience that they're speaking to, the communication channel. Is it Facebook or is it a press release? Content of the message, obviously, being critical. and then make a determination. This is, to me, an area where you can, a lot more often than not, you can always come to some good place with your client, and they'll be happy. And they don't want it. Once you explain this stuff, and many of you have, I'm sure, they don't want to go to jail. They don't want to get fired. They don't want to put the company at risk. They want to do the right thing. But they do want to drive some interest in what they're doing, which is also fair and makes sense. So here's some non-promotional communication examples. Press releases, first in human implant or first patient enrolled in a trial. Investor communications, that's always a tricky one. I'm always like, you got to get your SEC lawyer on this. That's not my purview. I will review it for FDA compliance, though. But I see a lot of stuff as an investor in different medtech startups myself. There are some communications that I receive where I'm like, it kind of feels like you're selling me here, on something that doesn't exist yet. So be careful. I definitely look through your investor communications, even press your earnings statements and all that. You get into this kind of battle between SEC, regulation FD, where you have to disclose certain information, and not promoting your product before it's approved. Market research. There's some things you can do there. Hey, doctor, you guys are all doctors. I'm going to give a presentation. It's unbranded, doesn't mention the company. You don't know anything about me, and I'm going to ask you if these messages resonate with you before a product's approved. That's something you can do. I get that question sometimes, and they're like, but we want our VP of marketing in the room, and he knows all the doctors. I'm like, no, that's not blinded. That's you pre-promoting. Corporate communications, not an end around these prohibitions. So there is more you can do when it comes to corporate communications. You can put certain information on your web pages and whatnot that even relate to some of these types of communications. But what you wouldn't want to do is take like that press release about the first in human implant and put it on your branded product page. But under corporate communications, it would be okay. If you are going to let your team, and I'm just going to ask Tracy, how am I doing on time? Good? Okay. So general rules to follow. If you are going to have your team, because occasionally I'll also get this one, we are at we're a cardiology company. We're going to be at Viva. We have a bunch of products that are in the pipeline, and we want to get a bunch of cardiologists, interventional radiologists, vascular surgeons, whatever, to test out our products. So we're going to get a room like this. You're getting pitched by your upstream product manager, because I was that guy, pitching my attorney back at EV3 a million years ago. I'm going to have a room like this, and I'm going to have a wet lab set up in it. I'm going to have the physicians come in, sign an NDA, and then I'm going to have them run through the wet lab and test some of our products with all of our engineers around collecting information. Can I do that? At the time it was Don Sorensen at EV3. I was asking if I could do that. And we figured out a way to do it. And I would say with my clients today, it's absolutely 100% lawful to do something like that. You're not promoting, you're getting information. And by the way, why did I want to do that? My bonus wasn't tied to product sales. I could care less. I wanted to get a bunch of physicians, like say I could get 30, 40 physicians testing a product for free, whereas normally that would cost me, potentially $100,000 to pay them all to do that, and a lot of red tape. So there are ways. If you're going to do that, though, you need to script that. That product manager needs to know how to talk in there. Do not promote it as safe or effective. Just follow your game plan, but you got to script them. If you are sharing data, let it speak for itself. We'll talk about that a little bit more in a minute. But that really comes out like if you have an ID trial, again, you have an interim cut, according to you make sure that's in your SAP, your statistical analysis plan. If you're going to do an interim cut, you would then share those data and not pontificate on them. It's just going to be like, this is what the drug or device did. We're not going to say how great it is and how it's a breakthrough and all that. If there's physicians that are consultants, you need to disclose that. Hyperbole, do not. So the red, the stop sign, avoid hyperbole. I had a slide in here, but I had to crunch this down where I had like 50 words not to use. And if you want that slide, I'll give it to you. But it was like all the things I've seen over the years. I'm like, no. So just avoid hyperbole. Avoid colorful adjectives. And I know it sounds kind of like, hey, we're taking the fun out of this, but you just want to be careful, because here's another thing I share with clients. Your product's at FDA right now, and they're watching you, and they're probably going to come to your booth, and they might have a Google search word for your product out there, and they're going to see what you're doing. And if they're going to get irritated and make a referral to compliance at CDRH, they now are in each device branch, or they're going to go to OPDP if you're a pharma company, and they're going to narc on you. So you just want to be careful. And if that happens, they may suspend your application. They'll be like, oh, yeah, you thought you were going to get your 510K in Q1? Well, guess what? We're putting that on hold because you're getting a warning letter. And I've had that happen. Avoid comparisons with competitive products treatments. That's a big one. Everybody's like, hey, ours is better than the next one. No, it's not. It's not cleared or approved yet. So just cool your jets on that until it is. Here's what scientific exchange is. I could have a poll question on what that is, because no one ever knows. I've gotten that question 100 times. What is scientific exchange? Well, it's not in any CFR, so we can't really find it. But it's essentially providing information from a medical affairs function to, for example, in response to an unsolicited request, maybe for some data. So if you're going to do that and you have a medical affairs function that's providing that information, even about a product that perhaps is, it's not approved for the new use, but you're allowed to provide that information under the safe harbor, you need to make sure that that information that you're providing is not promotional, it's not false or misleading, it's balanced, gives a complete look at the data, show them where the warts are, disclose that, and it should be appropriately, you should have a letter, an SRL, standard response letter, that discloses all of this information and follows a response. Look at the facts, circumstances, including frequency, context, audience, method, proactive or reactive of your dissemination. Here are some examples. So I just talked about data, presented phase 3 data, for example. A medical affairs function using responses, we just described that. A medical affairs section of an exhibit booth. Who works at a company who's ever been part of setting one of those up or has reviewed one? A medical affairs? I don't know. I haven't been in the trade show circuit for a while, but I'm not sure how many are still doing that. It can be helpful. Not very many. Yeah. Okay. Yeah, I'm not sure there's a lot of value in them personally, but some companies still do them. Scientific advisory boards. That is something that is very valuable, and that would be something that I can just described a minute ago with the wet lab, but it may be even just less tactical than that. It may be more strategic, like let's talk about clinical trial strategy. Let's talk about what products you want that aren't in the bag of our sales rep. That's not a promotional situation, and that could fall under the scientific exchange safe harbor. If you were going to supply data, here's some of the things that you can talk about. So this would be an outline for your press release. What is the indication you're studying? What's the study design? Is it randomized, controlled, double-blind, blah, blah, whatever? What is it? What are the primary and secondary endpoints? Are they pre-specified? Factual data about safety and effectiveness, X%, met our endpoint, didn't meet it, et cetera. I don't know why you'd do a press release if you didn't meet it. Probably wouldn't be very popular. The product design, mechanisms of action, constituents, patient inclusion, exclusion criteria. All those things are on limits, or within the limits. When you are disclosing data, include the N, the p-values, et cetera. I just said this, share the good, the bad, the ugly. Balance with safety. That's one question I get a lot is, should we include the ISI? Well, you shouldn't, because your product's investigational, and that ISI that you have, important safety information, doesn't match up with this investigational drug or device that isn't approved. But you may, if there are ISI for the investigational study, you could link to that, for example, or include those specific, that specific information. avoid comparisons. You'll hear me say that a lot. Disease awareness examples get this sometimes. Well, we want to increase patient enrollment, and I'm going to get to that in a minute. I won't read this slide. You guys can take a look at this. But there are things you can do under disease awareness to help drive awareness for a new indication, for example. Just don't do it in a promotional fashion. You can talk to payers. You guys have the information on the slide. I won't get into that, but and this guidance is readily available. And I actually hyperlinked it, and again, we're getting all these slides and whatnot to you. Displaying devices before approval, get that one a lot. The guidance in question relates to 510K cleared devices. Whether you can extend that to PMA devices, that's kind of up to you. You know, like I mentioned, this guidance goes back, it's 40 years old. They don't talk about PMA devices. They were talking about 510K cleared devices because the Device Amendments Act of 1976 was still, you know, contemporaneous to that guidance, and they were accounting for that. But you can put devices out there and show them, but you need to be careful on how you do that. Notice availability is really when you're trying to raise awareness for your IDE, for example, and you're trying to get investigators. So there's things you can do there, and there's an FDA guidance on that. Okay, now I'm going to quiz you guys. My law professor in me is coming out here. Your chief commercial officer wants to display a medical device at a company booth at an upcoming trade show. The booth captain, product manager, plans to put a sticker on this device disclosing its pending FDA clearance. It's not approved. If anyone asks about it, an engineer will be on hand to explain how the device functions. No promotion will take place. Only factual information will be conveyed. Orders will be taken for the new products. They're going to take orders at the booth so that they can be shipped right away. Company's got to hit its earnings. So what do you think? Does this sound okay? Does any of it sound okay? Like the first part, were we doing all right? Yeah, we were doing okay up till we were taking orders, I think. Yeah, I would be comfortable with that up until the orders piece. The rest of it, out of bounds. Mike, what do you think? Oh, so Mike, see, that's where you gotta talk to your SEC lawyer about that. Trace telling me I'm out of time. Do we have a break after this? We do, so I'm gonna eat into your break a little bit. Sorry about that. So your CEO is raising money. She wants to make sure current and prospective investors know the great things going on at the company. She issues a press release right away, includes quotes from the physician PI with game changer, safe, effective, groundbreaking. Does that sound all right? No, right? You're gonna be able to go back and say, look, I'm trying to keep you out of trouble. We can't do that. And I'll go through these recruiting slides pretty quickly. We just have a few. Who's recruiting, who has a clinical trial going on recruiting patients? Yeah, I'd say like 20%. Paul, you can let me know if that's representative on the chat. Looking like pending.
I'll say it since you don't have a mic. So poll results, 81% say yes.
Wow, okay. Are you sure you guys have, raise them high. How many have a clinical trial going on? You're enrolling patients. Okay, now I see about half the hands. So, okay, that jives with what we talked about earlier as well. So things to know. These are the do's and don'ts. If you are going out and starting to do some of the things around disease awareness, you're probably not triggering the informed consent process, but you could be if you start talking about this study and the product and all that. So be careful with that. You should get any recruitment materials reviewed by your IRB, very important. And then decide what's going to be covered from a financial perspective. That should all be in your informed consent form, your ICF, but I see a lot of times, the CTA and the ICF do not marry up. So make sure you're clear on what's being covered. And there may be, if you look at this advisory opinion, and we do have, I gave a previous presentation on this advisory opinion where you can cover some patient costs, for example, to follow up to ensure patient diversity in your patient population. Make sure your clinical trial, I already talked about that, lines up with your informed consent and Medicare rules. I won't get into Medicare secondary payer rule because you guys will probably start throwing rotten fruit at me if I do. Some rules for research payments: make sure they're at fair market value. That's one where you could subscribe to like Grantmaster or something like that, which is a database that will tell you what an average payment is for whatever service. It's really expensive. It's not that helpful from my perspective. When I used it, I was, anyways, in a past life, I would really, CMS rates are generally what you're going to go off of. And let's face it, everybody's trying to pay as little as possible. So clinical trials are generally not a place where you're trying to bribe anyone. But make sure your payments, I do see sometimes where I may be reviewing a budget with a client and I'm like, what is this? This looks like a hammer that's $1,500, like, back in some of the old federal budgets where they'd hide money in what is that? Well, that's a recruitment bonus. I'm like, well, tell me more about that. And that's the next slide. But look at your budgets to make sure everything adds up in there. Overhead payments, I could go on and on about that, where if you're trying to do research at UPenn, and they're like, yeah, we're going to add 40% to everything. I remember having a debate with one of their attorneys there once, and I'm like, what is overhead? I'm covering like your electricity? Like, what? That's not my problem. At some point, we're both going to be in trouble, in hot water with the government here for bribery. Be careful with your CTA drafting. I have a whole talk that I did on that. That's on our website that you can look at. I think this is the last slide. So recruitment bonuses. This is a question I get a lot. I understand the pressures that you all face getting patients into trials. And it's easy for me to be like, you can't pay bonuses, but you can't. I would never recommend that. There's a lot of restrictions. There's some state laws that exist where you can't pay bonuses. See, they may call it a bounty, whatever. Don't do it. Because if you think about it, if you're on the other side of that equation, if you get stuck in it or put into a trial, and it's clinical research, I'm not demeaning it, it's very important, but you wouldn't want to know that the person that convinced you to go into the trial is getting $500 or going on a trip somewhere. So that's the short of it with these bonuses. You can lawfully pay fair market value for recruiting efforts, however. And that is essentially my talk. Any questions? Yeah. Okay.
All right. First, is IRB approval of patient recruiting materials enough? Does the sponsor still bear responsibility for questionable content even if the IRB approves it?
Absolutely. 100%. Yeah. And you're going to have a lot of different opinions from different IRBs. WERB, who owns WERB now? I forget. They were bought. Does anybody know? Trivia? Yeah. WERB, Western IRB, was bought, I think. Quintiles? I don't. So anyways, they were one that was, they're quite conservative now because they got a little hot water. So just because the IRB says it's okay, you're still holding the bag. Next question.
All right. Any thoughts on long lead time capital investments, not taking an order or even selling, but just positioning the product for budget approval at an institution pending approval or clearance for an expensive piece of capital equipment?
Yeah. Answer is you can do that. And there is some discussion on that guidance that I talked about, that payer guidance that also gets into like value analysis committees, P&T committees, formulary committees, where you can talk with them. Because if you have this awesome thing they want, they need to budget for it in the government. I actually talked about that when Tom Abrams was still head of OPDP. I was out in DC at FDLI, and I asked him, hey, you just came out with this guidance. I have a lot of clients that sell really expensive stuff, and they need to get in the budget cycle like a year before the device is even approved. And he was like, yeah, we knew that, and that's okay. So he's retired now, so I don't know if that's worth anything anymore. But yeah, you can definitely start to talk about pricing. You just can't take orders. Absolutely don't ship product. That kind of goes without saying.
And Carrie online wins the trivia. WERB is now WCG.
Excellent. We'll have to ship her something, a Gardner Law travel mug or something. One more question? Okay.
Can you pay sales reps for getting clinical trial enrollments?
Oh, And by the way, I'm not providing legal advice to anyone asking these questions. I think that sounds bad. They're paying a bonus to the reps to get people on a trial. So first question is, is that what's happening?
It just says, can you pay sales reps for getting enrollments? So it doesn't say if it's a bonus or if it's like commission or.
My first question would be, why are your sales reps talking to prospective patients? That'd be my first question. And that would trigger the informed consent process. I think the government would also be highly skeptical of a sales rep talking to a patient about trial. An old FDA lawyer back in Minneapolis told me once, we were talking about proactive dissemination of off-label information and whether reps could hand a news or an article to a physician in a sealed envelope and everything, and there's a safe harbor around that. And he said, in his opinion, the answer was no, because he concluded that if a sales rep's lips are moving, that they are selling. And so I think that would be a pretty risky notion to have your sales rep out recruiting patients for a trial. That'd be my view. Great. Thanks, everybody. Sorry for getting into your break. And I think, Tracy, what time should we start again?
2:30.
Okay,
so about
great.
10 minutes.
Thanks. All right, we're going to start again. Oliver is going to be talking about international data transfers and how international businesses ensure compliance. So please, Oliver, take it away. Thank you.
Thank you, Mark, and hi again, everyone. The GDPR has already been mentioned this afternoon. What I will speak about is a very specific part, not only of the GDPR, but thanks to some recent case law, also the consequences of the verdict of the European Court of Justice called the so-called Schrems II decision, plus some guidance that we have seen in the last years, which means that international data transfer really is subject not only to the GDPR itself, but also to this case law guidance, and all that brings up a mix of, fair to say, I believe, a huge part of legal uncertainty when it comes to international data transfers. To give you a very well-known example where this plays a role in practice is the transfer, for example, of HR data in a group of companies. So imagine there is a company with its parental entity in the US, and they have subsidiaries in Europe. They have a software as a service agreement with a company that provides them with an HR software, and then they give sub-licenses to their European entities, and the entities use the software in order to process and transfer HR data into their headquarters. That's a very typical scenario, and HR data is, by the way, one of the most important field of GDPR compliance, and that is a scenario where the requirements for international data transfers come into play. Another example that's probably more familiar with many of you is everything around international data transfer when it comes to clinical trials. Because if you are operating with European sites, of course, there will be transferred personal information, personal data, patient data, and health information as well on an international level, which means you're again in the middle of the requirements for such international data transfer under the GDPR. And the GDPR in its Chapter 5 knows quite a number of legal grounds that you can rely on when it comes to transfer of data outside the European Union. And what looks like quite a variety on this slide, if you take a closer look, there's not much left that you can rely on, because this one, the Privacy Shield, has been invalidated by the European Court of Justice like 2 years ago. That was the consequence of the so-called Schrems II decision. If you take a look at the second and the third and the fourth column, then I wouldn't say you can ignore these, but the so-called binding corporate rules are an important legal ground for huge international multinational companies. It's quite a complex project if you want to rely on these binding corporate rules, but for the majority of companies that are working in the context of international data transfer, what remains are the standard contractual clauses, and that's also what I will speak about in this presentation. So that is really one of the most important remaining legal grounds for international data transfer on all levels. Besides of that, you have, of course, the so-called adequacy decisions. The European Commission can, by an official approval, say that certain jurisdictions have the same level of data protection equivalent to the one in the European Union. There has been approvals for a number of countries. You see some examples here. So Argentina, Canada, Japan, and some others are officially approved as having the same level of data protection as the European Union. In that case, you don't have an issue, But with regard to data transfer between the European Union and the US, the standard contractual clauses play, I would say, the most important role. So let's have a very brief look at the consequences of the so-called Schrems II decision. The verdict was from July 2020, and it dealt with the requirements for international data transfer, particularly to the US, and more precisely, in particular, with the consequences of the US surveillance laws, and to what extent that would still guarantee or not a level of data protection that is similar to the one in the European Union. You will all know about the consequence of that verdict. First of all, the EU Privacy Shield was killed. That is what we have seen on the previous slide. So we are missing one very important legal ground for international data transfer for more than 2 years now. You will have seen in the news that there's light at the end of the tunnel. About a month ago, President Biden signed the so-called executive order for a new EU-US data privacy framework. I will speak about that later, but as for now, we only have the executive order, and it has not led yet to a new alternative solution that would replace the invalid Privacy Shield. There are still some steps to go on the side of the European Commission until that will enter into effect. So anyway, the important message from the Schrems II decision was that yes, the Privacy Shield was killed, but the standard contractual clauses can still be used. And already at the time of this verdict, the back then actual SCCs have been under revision, not only because anyone expected this verdict of the European Court of Justice, but also because the old set of standard contractual clauses they will still be tailored under the previous data protection framework in Europe, the Data Protection Directive, and they have not been adjusted to the requirements of the General Data Protection Regulation. So the Commission was working on a new set of standard contractual clauses anyway. This new set is in effect since June 2021. I will come to that on the next slide. But let me already give you one important message here. It's not just enough to rely on these standard contractual clauses, because one consequence of the European Court of Justice verdicts was that the consequence is that you also have to carry out a so-called transfer impact assessment. You cannot only rely on the SCCs, you have to assess the privacy framework in the country where you would transfer data to. And that is quite a challenging topic. We will come to that later as well. But the key message here already is it's not all about the standard contractual clauses alone. There's some additional homework that you need to do if you want to work with these standard contractual clauses. So very shortly after the verdict, we saw a lot of interesting responses from the regulator or reactions to this decision. First of all, the European Data Protection Board, which is the umbrella association of all European data protection authorities, provided recommendations, including how to produce such a transfer impact assessment that I mentioned, and what so-called supplementary measures might be, because the key idea of the transfer impact assessment is to assess whether you have an equivalent level of data protection or not. And if you come to the conclusion that this is not the case, then you're obliged to implement additional supplementary measures in order to protect the personal data that are transferred outside the European Union. I already mentioned the new SCCs. These have been released in June already, 2021. And also important to see that while everyone, was kind of unsure about the reactions of the authorities in terms of potential investigations, we have not seen serious enforcement action, at least not in the life science sector in a broader sense so far. The authorities in Europe are very much focusing on the huge online platform services. They are focusing on services like Microsoft and many other well-known services that also contain the transfer or exchange of personal data between European companies or customers and their US service providers. But the particular life science sector in a broader sense has not been subject to any investigations so far, which is actually good news at that point. So what's the difference if we look at the old SCCs and the new SCCs? The old set of SCCs has been not very flexible. There were only 3 different modules that you could make use of, 2 different kind of so-called controller to controller, standard contractual clauses, and 1 set of clauses for the use between controller and processor. Compared to that, we have a much more flexible approach with the new SCCs. We have 4 different modules. And depending on the roles of the parties that are exchanging data, you can pick the relevant modules, plus certain clauses that you will or will not use, and all that can be composed into one set that fits your individual needs for the specific data transfer between 2 or more entities. 2 or more is a very important buzzword here. And what's also important is that the new set of SCCs contains a so-called docking clause, which makes it very easy, in particular in very complex chains of companies or companies that belong to a group of companies that you can add step by step to the SCCs. Now, that's very flexible as well, and one very important improvement in this new set of standard contractual clauses. So what's the supervisory authority views on the use of SCCs? First of all, there are some important deadlines that you need to take into account. The most important one is the second bullet point here, because the authorities expect companies that have entered into the new SCCs for existing DPAs before the 27th of December 2022, which is very close now. So very important for companies that might still rely on the old SCCs in some cases. Now it's the last weeks that are starting in order to adjust that and to change to the new SCCs. The 27th of December is the last deadline for that. And as I already mentioned, the new SCCs do not come alone or stand alone. They come with the additional obligation to create a transfer impact assessment. And we have also seen very important guidance, that was too fast, of the European Data Protection Board on how to carry out such a transfer impact assessment in detail. It's a step-by-step approach. We will come to that later. But let's go back to the slide. So what would you do in the scenario that I presented in the beginning of this presentation? You would add the relevant SCCs in this scenario between the different companies. You would, of course, need to individualize them, and that would be your way to secure the international data transfer. For this example, when it comes to the exchange in the context of HR data. It's a little bit unsecure with regard to clinical trials, because there are many different opinions on the relation between the sponsor and the site. It depends very much on the individual case, of course. I don't know if some of you have made these experiences already, but some sites even see themselves as a processor, and they would provide you with a completely different set of modules for the SCCs. Compared to sites that would say, no, we are both individual controllers. And others would say, and again, it depends on the individual case, we are joint controllers. We are jointly together determining the data processing that is relevant for a certain study. And that can end up in quite tricky situations, to my experience, because if a site insists on having a certain role, let's say they are insisting on being an individual processor, while you believe you're a joint controller together with the site, then at some point of time you will have to answer the question, what do I do? Do I try to convince them that they are following my position and we use a different set, or we maybe do not need any SCCs at all, or just for the sakeness of getting the clinical trial started, I just follow their position even if I believe, or my legal department or lawyers believe, that it's not a joint controllership, but it's a controller-to-controller relation. So that's sometimes very tricky. My advice always is to see it from a risk perspective. what would be the worst case if you would rely on not the right set of modules under the SCCs. I think in the majority of cases, this risk is very limited in terms of not only investigations, but also in terms of potential fines. I wouldn't say at the end of the day, it doesn't matter which module you use, but I think it's fair to say that one can use a very practical approach here and should not, well, end up into endless negotiations about what is the right scenario here. I think a practical approach is a very good advice in that scenario. So let's assume both parties agree that they are independent controllers, then you would use the module 1 of the SCCs in this case, and everything's fine so far, apart from the individual homework that you need to do in addition. What we did at Fieldfisher as a little gimmick together with our legal tech team, we created a tool where you can automatically compose the right modules of SCCs that are relevant in the specific context and in the specific scenario. You just need to answer a couple of questions. It doesn't take 5 minutes, and that's at least a first step that can make it easier to find the right and compose the right modules for a specific case. But as I said, it's not only about the modules. You need to do some individual homework. So SCCs sounds very easy from a first point of view. It's a standard, so that makes it very comfortable. But it's not all about standards. It's actually the opposite. You need to do a lot of individual work. You need to assess your data flows. As I said before in the example of a clinical trial, it's sometimes difficult to correctly define the role of the parties as controllers, joint controllers, controllers or processors. All that has to be done. So such a tool can help, of course, but the information about data categories, the purpose, the individual and security measures, the technical and organizational measures that are in place to protect the data, all that needs to be assessed. And the SCCs need to be filled out accordingly. It's never just print out and add some like general information. If you want to do it at least a little bit proper, you will need to assess quite a lot of information regarding to that specific data flows. And then, as I said, the data transfer impact assessment plays a very important role. And we have guidance about that. Many of you will know that from the European Data Protection Board. That recommends a 5-step approach, actually. The first one is very obvious, know your transfer. Of course, the bigger the company and the more complex your relations in data transfer with other companies, you need to assess, of course, in which cases you have relevant data transfers at all. Then you need to identify the transfer tools you are relying on, and then step by step you come to the final version of your transfer impact assessment. And the last step is, of course, that you have to re-evaluate the TIA at appropriate intervals. That can be different from company to company, what is appropriate and what not. But at least the first 4 steps are important to take if you carry out such an TIA. Then also very interesting and important recommendations from the EDPB with regard to supplementary measures. What do you have to implement if you come to the conclusion, like in the US, that basically the privacy framework here is not equivalent with the one in the European Union? There is some guidance from the EDPB in that regard as well. However, there are a lot of uncertainties what you have to do in individual cases. Of course, you can implement contractual measures. You can implement technical measures like encryption. You can define organizational measures in terms of that a party has to report if they have a request from a surveillance agency to the other party. But all that will generally not overcome access to personal data by public authorities. So everything you can do will never lead to a situation where a public authority, a US surveillance agency, would be impressed by that. And that's really the challenge, how you can solve that. What is important from a technical perspective is encryption, and you also find very interesting guidance from some authorities how encryption needs to be well set up and also managed with regard to the keys. So that is one very important from a technical perspective, I would say the most important thing that you would need to consider in the certain relation between two parties exchanging data. Well, and then I said there's light on the tunnel. On October 7, President Biden signed this executive order. And the new data privacy framework basically contains three key elements. First of all, it's the executive order itself, of course. Then the commercial data protection principles to which US organizations may self-certify. That is the same approach like the previous privacy shield. So that will be the same if this new agreement will come into force. And then also a very important part are the Department of Justice regulations. Oh, that was the wrong side. Because the two key criticism of the European Court of Justice in its Schrems II decision was that there was no appropriate redress mechanism under US law so far. So that was one very important thing why the ECJ said the privacy shield would not be valid anymore. And the other one was the very far-reaching rights of surveillance agency, and both topics have been addressed by this presidential order now. There is, in particular, a new data protection review court that will be established at the Department of Justice, and that is one very important part of this new data privacy framework. So if we look back into the slide that I presented in the beginning, the question is how does that fit into the system of legal grounds under the GDPR for international data transfer? I would say that it is a mix between appropriate safeguards like the previous privacy shield, so the self-certification process would probably belong into that column, and the new adequacy decision that is still to come from the European Commission would then, once it's in effect, belong into this first column. So actually a mix, but before we have this mix ready, the EU Commission needs to do their homework as well. On this side, you see once again the key bullet points about what contains this new framework. I already mentioned that EU individuals may seek redress from a multi-layer redress mechanism that should now be implemented as the already mentioned independent data protection review court. That is one very important part of it, and as I said, the US intelligence agencies will also adopt procedures to ensure effective oversight of new privacy and civil liberty standards. That's it very briefly. The important question now is what is the timeline and what has to be done on the side of the European Commission. And what I can say is that this will take quite some time because the European Commission needs not only to involve the European Data Protection Board, which will now start to work on their position and on a legal report, how they see things, and if they believe that this new framework complies with the requirements of the European Court of Justice. But also the member states will have to do their homework. They have to submit their positions too. So if we take all that into account, I think before summer 2023, we will not see this new framework into force, maybe even longer. Depends, of course, very much on, well, how critical or not critical the positions in particular of the European Data Protection Board will be. Key question that everyone is asking, of course, is will the new data privacy framework be challenged again? The answer is very clear and didn't come as a surprise. It will, definitely. That was what everyone accepted. Max Schrems and his organization, they were only waiting for this executive order in order to check if they would see room for another court case that they will bring up. And everyone is very sure about that they will do so, and they already announced on their website that you can see here on the screenshot that they do not believe that this executive order complies with the requirements for international data transfer as set out in the Schrems II decision. So it's absolutely clear that they will take legal action against it. The only question is not only will that be successful or not, but also, of course, how long does the court proceedings take, and how long it gives that time for the industry to rely on this additional legal ground for international data transfer. So challenging times ahead. A lot of legal uncertainty remains. And the most important advice that I would give at the end is really always keep in mind that the GDPR has a risk-based approach. And of course, it's a difference if you are Google or if you're a life science company. That's really one important advice. And I think the mistake that many make, and also the mistake in the view of many data protection authorities in Europe, is that they have the same view on completely different kind of industries and different data protection in different contexts. That does not, of course, not mean that life science companies can take it easy. It's the opposite. You have to take it serious. But the risk-based approach, I think, helps in many ways to find a practical approach. In some cases, also find a lean approach and not overdo it, depending very much on the, individual context of the exchange of data, not only in the international context. Thank you. Questions, please, if there are any. From the remote audience, Amanda?
I don't see any. Do you see me? Okay.
Okay.
Nope. Yeah.
Okay, good. Thank you. Then I hand over again, no, not again, to Paul.
Well, hello everyone. Can you hear me okay? All right. Thanks again for coming out today. And I know it's getting long in the afternoon and you're all full and ready to take a nap. But so we get to talk about a really exciting topic, medical device cybersecurity. And this topic is interesting to me in part because I've had a background as a privacy lawyer, and I'm interested in cybersecurity from that data protection standpoint. But this is also a key topic from a device safety and effectiveness standpoint, and that's a really fascinating intersection for me in terms of my background. So let's dive in. As you know, I'm from Gardner Law, so my practice is with that firm. I've been involved in medical device privacy, healthcare privacy for some time, and cybersecurity as well. All right, let's dive in here. So some of the things that we'll be talking about today are medical device security generally. And I want to start with saying I'm a lawyer. I'm not a technical expert in security controls and all of the details of encryption, and I will not be diving into that level, but I want to talk to you as lawyers and compliance professionals and regulatory folks that kind of a high-level understanding of what is it that FDA and what is it that we need to be thinking about in terms of medical devices and cybersecurity. So we'll talk about that. We'll talk about FDA draft guidance this year that came out, some details about that, some summaries, give you some information. It was a long document, so we won't go through all 50 pages, but we'll talk through some of the highlights there. We'll also talk about reporting requirements. What is it that you have to do if there's a medical device, quote unquote, cybersecurity breach? And what do you not have to do? So we'll talk about that. And then also some other considerations around cybersecurity that may be relevant to just think about and deal with outside of FDA, outside of some of these other directly regulated issues around medical devices. And then also just, I can't help it as a privacy lawyer to not mention at least some of the US privacy things happening at the end of the year here and just bring those up briefly, but we'll save that for the end and keep that short. So we'll go from there into a poll question, I think just to kind of understand who I'm talking to in terms of your interest in medical device cybersecurity. And hopefully a few of you have some interest. Does your company have a device with cybersecurity risk, at least as you understand it? Any hands raised here? See a few, maybe half, maybe a little bit less. We'll give a second for the online audience here.
All right, results are in. 68% say yes.
Okay, so that doesn't surprise me. I think more and more devices are connected. They have some sort of login or programming involved in the development of the device. There's something there. Maybe it's a USB port. There's something on the device that allows some sort of cybersecurity vulnerability. And that's what we're talking about today. You've probably heard about cybersecurity at some point in the news related to medical devices. Maybe it's fear or concern about my device, what could happen. Dick Cheney, former vice president, famously had a defibrillator implanted that the concern was, well, could he be attacked or harmed remotely from the next room at a hotel or something else with this device implanted that could potentially harm him? And so the concern was, well, okay, let's turn off the wireless connectivity of this device and that'll help protect him. So famously that did happen. They turned off the device, wireless connectivity, and that's been confirmed. So interesting, just an interesting perspective on this, and that's not changed. About 15 years later, we're still talking about medical device cybersecurity, and connectivity is a big part of that. And you thought we were talking about only the FDA, but we're also going to mention the FBI. So today, about a month ago, and in September, there was a alert sent to private industry about potential cybersecurity risk of medical devices. And I thought this was really interesting, and so I had to share that. Just even the FBI is raising this and some of the concerns, and I'll just read off a few of the things that they noted around this. So they called out default configurations and passwords. So a medical device that's, say, at a hospital, and if they don't change the password and it's, username is username and your password is password, those are things that can lead to security risk. Or devices that have vulnerability patching that's been delayed too long, so it's running on Windows and you don't have the latest security updates, things like that. Devices that aren't designed with security in mind, so there might be just vulnerabilities that haven't been considered or documented, especially connected devices. They called those out, or Internet of Things devices. Also, device types. So there are certain devices that might be more prone to cause patient harm through a vulnerability, and those would be things like implantables. You think of pacemakers or pumps that might be implanted, et cetera. Things like that can be especially risky. And end-of-life or legacy devices, so devices that have been on the market for so long that they're no longer supported or have updates, patching, security updates available. So the FBI is paying attention to this, and this just came out very recently. So that was most likely, most hospitals, providers that receive those updates, and so you might start seeing more and more questions about these topics. So we talked about FBI. What about the FDA? That's what we're really interested in. The FDA has a very specific emphasis on device cybersecurity, and it's not about protecting patient data. Let's be clear. That's other regulators deal with that. What the FDA is concerned with is device safety and effectiveness, and it's also concerned with, to an extent, the confidentiality of information. But that's again about, is the device protecting information that might be used to interfere with the device in some way. So that would be, again, username, authentication, protocols, ways to access the device and interfere, damage, or manipulate the device. And I won't read the quotes, but those are, I think, just illustrative, and you can see them in your packet around what the FDA is thinking about in terms of device cybersecurity. So there was some new FDA draft guidance that came out this year in April. What's interesting about that to me is there was a previous draft guidance in 2018, and we have another draft guidance, but there hasn't been anything final in a little while. So that these continue to be non-binding, they're recommendations, and they're not even implemented yet. So they're just sort of clues to what the FDA is thinking about, but they're not binding on us at this point. But I think still helpful to consider and be aware of the direction that the FDA is going. So for example, here we have an emphasis on connected devices, and I think that makes a lot of sense. If you're familiar with any of the many potential risks of connectivity, that's a major concern of FDA. So they've focused on that in the guidance. They've focused on that in terms of where are the risks, and that's relevant here as well. So one of the comments they've made, and I'll just read this briefly: increasing connectivity of medical devices has increased the potential for cybersecurity vulnerabilities in these devices. So it can either affect the device itself or any systems linked to the device. So think about how a device connected to, say, a hospital network can also make that network itself vulnerable. And there's been concern that, well, if a device that's placed in a hospital, and if you've been in the OR or any other rooms in a hospital, there's dozens of devices that may or may not be connected to the internet, connected to that network, and even a vulnerability in one of those devices might lead to vulnerabilities for the entire hospital network. And that's a concern that FDA and also a lot of providers share. All right, so obviously the FDA is concerned with that, so they've offered some recommendations around device design, and these are just a few kind of high-level things to think about. And if you're involved in cybersecurity, generally you'll recognize these themes. But authenticity or integrity, the idea of the device needs to be able to interact with other devices, other entities on the network, and trust that they are. There's a kind of a trust level that's baked into the design of the device between it and other, whitelisting other things to make sure that it's communicating with the right entities, the right devices. Authorization, there can't just be sort of carte blanche access to that device. It needs to be controlled and authorized. Availability, obviously, you don't want to have a device that fails to work simply because someone interferes with it or sends a signal. It needs to be available all the time, or as much as possible. Confidentiality of key information, so protecting that information from someone who might be able to use it to access the device or interfere with the use of the device. And then finally, and this is really relevant more and more, the ability to patch and update the device. There's always going to be risk when a device loses that updated, as soon as there's a vulnerability announced through, maybe it's a Microsoft announcement or something in Windows, and maybe there's a programmer that's using a Windows-based operating system, there may now be a device vulnerability through that programmer. So keeping the updates going at an appropriate pace is critical. I'll pause here. Any questions so far? I know we've been moving pretty quickly. All right. Just a couple of comments here from the FDA that I think are helpful to think about. We've talked a little bit about misbranding and labeling today. The FDA has made it clear that they view potentially really any sort of vulnerabilities that are known in advance to be potentially foreseeable, reasonably foreseeable, and therefore should be addressed in the design of the device. So you think about the design and development and production of the device that has to do with potentially adulteration. You could have concerns around that if the device isn't designed in a way that reasonably foresees risk to the patient. You might also have inadequate cybersecurity controls, and they're not communicated well. There could be weaknesses there that lead to potentially a misbranding or other concerns. So this does relate to, and we're kind of getting a peek behind the curtain at FDA's thinking that these could be concerns around even compliance with quality regulations and other things. So what about pre-market submission? What do we do to prepare to submit information? The FDA is also giving us a little bit of a view there. You can see how a lot of different parts of these of a device, we just talked about authentication, about integrity, about these different controls that you may need to aimed towards an objectives around security. Well, those are all relevant to the extent that the device, where is it used? How is it used? What are the indications? Will it be in a hospital? Will it be in a locked room in a hospital? Will it have, public access to it? Things like that to consider. And then ultimately, is there a risk of patient harm through any of these device vulnerabilities? And how exploitable are they? So there's lots of different considerations here that the FDA is giving us. But how do we come to these conclusions? How do we draw conclusions from this? We have to do some risk assessment. And we'll talk about that a little bit, a couple slides from here, but just thinking about submission and what that might look like. So for example, you might have and this is an example FDA gives in the draft guidance. For example, a cybersecurity risk assessment performed on a simple non-connected thermometer may conclude that the risks are limited, and therefore such a device needs only a limited security architecture. Few security controls based on the technical characteristics and design of the device. So you can kind of see how there's baked into this concept, there's a little bit of a risk-based approach that they're thinking about. Okay, some devices may not have the same level of security risk as others, and we need to account for that, and we don't expect necessarily this enormous architecture diagram and all of these things to demonstrate your security controls if it's not relevant to that particular device. So another aspect of the guidance that I think was kind of enlightening to me is the concept of transparency. So even though we don't necessarily think about cybersecurity in terms of device labeling, the FDA is kind of suggesting that, we might expect to see device security-related information in our labeling, especially around interconnected devices, so devices with that connectivity, going back to that theme. And that's, I think, important to keep in mind. A lot of times we think of labeling on a totally different idea, but the concept being that if we are going to put a device into the hands of a provider and cybersecurity is relevant to the safety and effectiveness of that device, then we should be transparent about what they can do to ensure that is upheld throughout the device life cycle. All right, so we're going to do another poll question. Does your company have any devices or devices in the pipeline that would include cybersecurity information in the labeling? Anyone done this already or thinking about it? I have a few hands here. How about online?
91% said no, so 9% yes.
Yeah, and that's not too surprising. I think this is fairly on the cutting edge a little bit to be doing this, and also many devices don't have cybersecurity risk, and you might have a catheter that has no connectivity or something like that. But definitely something to be thinking about as you go forward. Should there be cybersecurity information in the labeling? Yeah.
So as an Apple Watch is a medical device, does it have a current cybersecurity information on their label?
That's a good question. I don't know offhand. No, that's a good question.
So the watch itself is not a medical device, it's the apps that are cleared. And I would assume that the apps would have cybersecurity. I'm sure it's electronic, yeah.
Another question here. Yeah, thank you.
Maybe you can answer this later, but I'm just curious what the FDA's concern is regarding 5G on devices that transmit 5G, because I've heard that there's some health concerns with that.
I don't have any indication of what that. Yeah,
position from FDA
I haven't. No, but yeah, thank you for that. Yeah.
I have heard the same thing.
Yeah. As far as the draft guidance, so we did talk about security risk assessment, and a part of that is there's a total product life cycle of any device. You have design, you have testing, you go through even trials, and eventually, hopefully, post-market use of the device. So FDA is looking to companies to think through that and plan for that. They're signaling that they would like to see kind of a total product life cycle approach to device security, and also approaching this with generally a risk management approach. And that's what's interesting about that is when you think about security risk assessment and versus sort of standard FDA testing and consideration of safety risk, security risk is usually based on what are the exploitable characteristics of this system. So how could it be exploited? How likely is it to be exploited? That's really the focus instead of just a probability. It's difficult to quantify security risk at times, but if there's exploitable avenues with that device, FDA is signaling that they're interested in seeing consideration of all the exploitable points or of entry or whatever to that device, and how can you secure it against those. So I think that's helpful to understand. And then also, if you do identify security risks, what sort of things do you do with that? Ultimately, you're going to try to address those in the design because you're considering this up front. And then if you can't fix that in the design for whatever reason, what other compensating controls could you put in place or include in your information provided to a customer, for example, to try to avoid that risk or mitigate that risk? Ultimately, there might be some risk that has to be transferred to the user, but FDA is indicating they would like to see transparency about that so that users are informed about risks and not simply transferred to them without any awareness of those risks. A little bit more about security risk management. So obviously documentation. So if you're going to make a plan for how you manage the risk of the device, document that plan. If you don't have any sort of documentation, did it really happen? I think anyone who's interacted with FDA can attest to that. So there's an important step here is if you do a security risk assessment and go through, maybe you pen tested the device, maybe you did vulnerability scanning or any other activities to try to secure that device or check for vulnerabilities, document those and ensure that you've addressed any risks that are identified. And something that I've mentioned before, but it's just sort of a focus of this draft guidance is the idea of the total product life cycle. So we mentioned earlier legacy devices being a concern. That's absolutely something that FDA is trying to consider in advance with this is how will you as a device manufacturer consider the entire life cycle of the device, and what do you do when it can't be updated or patched anymore? What kind of plan do you have in place? Okay, so one more poll question, and after this we're going to shift gears here a little away from FDA guidance and towards some other more cybersecurity considerations. Has your company received questions from customers about device cybersecurity? How many have experienced that? Yeah, I see about maybe 30% here have gone through that.
And 57% said yes online.
Yeah, so that makes sense. I've seen lots of this, and even in contracts, there's, will you sign these reps and warranties around how you'll handle cybersecurity throughout the life cycle of the device, patching, vulnerability management, who's responsible for device configuration, all of these things, and more and more I think that's going to be the trend. So there's some other considerations here. FDA has, in addition to the guidance, also recently released this video targeted to providers and saying, here's some questions you should ask or consider asking when you're purchasing medical devices. And here's just a list. I think it's interesting to me. This came out in October. So just some of these questions are pretty basic, but do you have an answer or response to these if you have a cybersecurity a device with that kind of risk? And I think if you don't have an answer, you probably should think through that, because most likely these questions are only going to get more common and more intense. What about reporting medical device cybersecurity breaches or concerns? Right now, the FDA does not have a device reporting requirement specific to cybersecurity breaches, if you will. So if there's a loss of data through a medical device, we would go to other regulations. We'd go to HIPAA, we'd go to FTC and other state laws to think about those things. FDA is focused on device safety and effectiveness, and that doesn't change just because we're talking about cybersecurity. So there may be situations where a post-market cybersecurity issue is identified where you would need to disclose that or find a solution to that. But again, it's not unique to cybersecurity. It goes back to MDR and those other mandatory device reporting rules. One thing I'll highlight is there's a series of cybersecurity safety communications on the FDA website, and I've linked that here, but you can see an example. So there might be a recall or other things associated with devices when vulnerabilities are discovered. And in this case, it was a device insulin pump, and so within that, with that device recall, they were simply informing patients, here's the vulnerability we found, and here's how you can mitigate that. So that was a recent one, but there are several examples of these kinds of safety reporting incidents. A few other things to think about with cybersecurity. So obviously, device safety and effectiveness is really important, and the FDA is dealing with that, but there are other laws that apply as well. You might have obligations if you're a covered entity or a business associate around cybersecurity. You might also find that in the design of your device, you can address some of the risks around potentially becoming a business associate or exposure to PHI by designing the device in advance to limit access to that or avoid your teams accessing that information. You can also find that the FTC and other regulators also regulate the security of information. So again, the data security side of things. State laws, so breaches and other incidents can also be relevant to device security. So being aware of what data the device collects, what kind of controls you have around that and the life cycle of that data. And then I'm not a product liability lawyer, but obviously along with device security, there's some product liability concerns as well if your device is faulty in some way. So a few takeaways here. Again, the FDA draft guidance is draft. It's not binding, but I think some takeaways we can draw from this. Design for security, address that security throughout the life cycle, have that secure product design framework. Have a plan for any cybersecurity vulnerabilities you identify after the device is on the market, or even as an IDE, it's in a trial. What do you do if something comes up? Have a plan for that. And then how do you share cybersecurity risk information? Do you have documentation that does that either through labeling or through a submission process with the FDA? And then also think about how cybersecurity affects device safety and effectiveness and privacy. Those are both interrelated when it comes to this topic. And I think a lot of times when you deal with kind of the design side with engineers and so on, they're more focused on the safety and effectiveness and maybe aren't thinking about data security. So kind of bring those together when you can in the design phase. And then also be prepared to talk with FDA about cybersecurity when there are submissions or even post-market issues. Have some thoughts about what are you doing, what's your risk management plan around cybersecurity. So I will pause here. Any questions online or in the room? Great, okay. So just a quick couple notes on privacy I had to sneak in here. Quick chart just to compare some of the current state privacy laws. I wanted to highlight that California has some revisions to the CCPA that will be effective on January 1. So mostly, and we'll talk briefly about this in another slide, but some limited changes. And then Virginia, we also have a new law coming into effect on the 1st. So you can see a little bit about this here. If the law applies, you'll have a whole new set. Hopefully you're already dealing with this now, but in the next month and a half, you'll have a lot to do if you're not. And then California, so briefly, there's just a couple of exclusions that are expiring, and they're partial exclusions, but employee, applicant, and business-to-business commercial data exclusions from the CCPA are expiring at the end of the year. So that's a significant, noteworthy change. And then Also, there have been some updates to sale and sharing of personal information. So if you haven't looked at your privacy policy or you are subject to CCPA, think about do you actually disclose the kinds of things you need to disclose given the new regulations? And then also, there's also been some enforcement starting to uptick on CCPA, so be aware of that. And the recent Sephora case is an example, I think, of the kind of enforcement trends we might see in the next year, especially as the regulations are hopefully finalized. We've had some new proposed regulations in the past week, so in the next, hopefully, few months, we'll have final regulations for the California Privacy Rights Act, and that should inform us better about how to comply in 2023. So that's about it. Any final questions?
What was the Sephora case?
So there was a recent, and it was a settlement. But ultimately the AG in California there's a complaint that Sephora had been selling personal data, and as you know, the California Consumer Privacy Act doesn't permit sale of consumer data if someone's opted out. And what the AG said, and which was most noteworthy, I think, is if you have a global privacy control signal, which is sort of an automated browser signal that you transmit when you visit websites, that consists of an opt-out request. And many websites do not acknowledge or even read those signals. So that led to, in part at least, to this settlement for $1.2 million. All right, any other questions? All right, thanks everyone. And I'll pass it back to Corey.
Thanks. It's working. Yeah, thank you very much. I now have the pleasure to give you an update on the EU medical device regulation, on the recent trends and developments before we then enter into a very exciting panel discussion for which I'm very much looking forward. But now to the EU medical device regulation. And I will very briefly give you an update, or maybe give you the backgrounds of the date of application and what the current problems and public discussions are in Germany, before I'm then hopefully able to give you some solutions about the problems that we are currently having. And then concluding with an update on the other key markets that we have in Europe. You all know that UK is not part of the European Union anymore since the Brexit that is effective since February 2020. And Switzerland, Mark, sorry, I don't want to stress your feelings here. And Switzerland, of course, is not part of the European Union, as you know, but not even part of the European Economic Area. So it's kind of called a third country in view of the EU MDR, like the UK is. So the EU medical device regulation, I think you're all very, very familiar with it if you are commercializing your devices in the European Union. Just very quickly, it has been published in the European Journal in May 2017, and there was initially planned to have a transitional period of 3 years. Then because of COVID, an additional moratorium of 1 year applied. So the date of application is May 2021. And you are all, or most of you are lawyers, you know the difference between a directive and a regulation. With a regulation, you're in the very comfortable position that it directly applies within the member states. So it is not necessary, as it was for the old medical device directive, that this has been implemented by an act of the national legislator, that it is applicable in each member state. So this regulation sets up a fully harmonized legal framework for the regulatory framework for medical devices. So whenever you place a product legally on the market, you manufacture it, you have to do clinical investigations, then you can look up to the MDR, and there you find the harmonized framework for the entire European Union. This is the good news, or the good message. The bad news is that it hugely extended the regulatory obligations, not only to the economic operators, but also to the manufacturers when it comes to the technical documentation, design, and intended purpose of medical devices. Just to give you an example for this, the MDD, so the old regime, the Medical Device Directive, applicable until May 2021, had only 17 articles and 10 annexes. And when you now look up the EU Medical Device Regulation, it has 127 articles and 17 annexes. So you can, alone from these numbers, understand what kind of challenge manufacturers and all the other economic operators like importers, distributors, authorized representatives, but also notified bodies currently are having to keep with the regulatory obligations up to speed. So what we have seen in the past for our clients and for the entire MedTech industry, what are the major challenges in context to the MDR? This is certainly clinical evaluation. It increased a lot. So with the MDD, there was still a focus on purely safety of a medical device. Under the MDR, there is not only safety, it's also performance data that you have to obtain when you do clinical investigation for your medical device. And this means you have to show clinical benefit. And clinical benefit, the legal definition of it is that there is a positive impact on the patient health. So it's a shift from a focus on the safety of a medical device to also obtaining performance data. So this is one of the greatest challenges that medical device manufacturers are currently having when they want to obtain an EU declaration of conformity according to the MDR. What is also quite challenging, we have new economic operators identified, not only identified but addressed in the EU medical device regulation, and they have imposed a lot of new regulatory obligations. We now have not only the manufacturer and the authorized representative, it's also the importer and the distributor who have to fulfill certain duties. And when you have a look at Article 13 for the importer and Article 14 for the distributor, is such a page of regulatory obligations that they have to fulfill. And for you, if you are a manufacturer, then you also have to consider that it's best and common practice in Europe, in the European Union, to include these regulatory obligations of importers and distributors in the respective agreements that you might have with them. So we have seen a lot of homework that was done by manufacturers by just concluding quality agreements or attachments to existing distribution or importer agreements. Then a challenge, certainly just for the sake of completeness, or I don't have completeness here when I report about 127 articles, but what was only a great discussion in the public, the upgrade for software as a medical device. Most of the softwares under the MDD were Class 1, and Class 1 means that a conformity assessment procedure does not require the involvement of a notified body. Most of them, I think some data say 80%, now receive an upgrade to 2A or 2B, risk class 2A or risk class 2B. And this needs the manufacturer for the software as a medical device to execute service agreement with notified bodies. And we have a real shortage of notified bodies currently. And the reason for that is that we have a switch from the MDD to the MDR, and there were a few transitional periods applying, but not for notified bodies. So the EU legislator has said that when the MDR enters into force, the accreditation of a notified body will become immediately void. So you're all aware of the change of the regime in the US in contrast to the European Union. We don't have an FDA, we don't have a competent authority who is issuing a marketing authorization for a medical device. We have notified bodies. A notified body is a legal person, and the TÜV Süd, TÜV Rheinland, and DEKRA, they are GmbHs, and that they are empowered to do this conformity assessment procedure and then issue an EU declaration of conformity. They need to run through an accreditation procedure that they can call themselves notified body. So this has been done in view of the MDD. With date of application MDR, all the accreditations of notified bodies become void. That means that they have to start from nil, from scratch. They now have to get an accreditation under the MDR. And you can see that there is a huge bottleneck of notified bodies currently applying in the European Union. We were still in very comfortable times in 2012, 2013, where we had around 80 notified bodies. And during time, it's slowed down to 59. That was because a lot of little players just stopped business. We had some mergers of some players. So we had a constant number of 59 notified bodies from 2016 on. And then I told you the initial date of application of MDR was May 2020. So all the notifications became void, and in parallel, the notified bodies tried to get an accreditation under the MDR. And this is extremely burdensome, very much time consuming. And this now leads to the fact that I think BSI Amsterdam was the first notified body to get this accreditation in January 2019. Then TÜV Süd came, DECRA came, some Spanish notified bodies. And now we are in a situation, 2022, 1 year after the date of application of the MDR, that we only have 34 notified bodies and much more workload. So this is a table that was drafted by the German BV-Med, and now I'd show you by a slide of MedTech Europe, that you can see that not only the number of notified bodies goes down, but also the workload goes extremely up. So I'm just telling you that a conformity assessment procedure under the MDD required to see if a medical device is in compliance with 17 articles, and now it's very easily set with 127 articles. So the capacity and the workload, there is a huge gap between both of these scales. So this leads to a fact where the public discussions in Germany and all among the European Union, we are now fearing a lack or a bottleneck of supply bottleneck, because we also have a transitional period for CE marks. You can see that we are here in a rather comfortable position because we can say that from date of application, May 2021, the CE marks from, we call it legacy devices. And legacy devices, this is a term that describes that it's a medical device that is still with an MDD CE mark, so that legacy devices can still be marketed. So the CE mark does not become void after the date of application of the MDR. You can still use it until your CE mark is effective. But there is one total deadline, and the MDR says after May 2024, you are not allowed to use your MDD certificate anymore. Some numbers, statistics say that still 23,000 legacy devices need an MDR certificate. And when you have a look, that only 8,120 manufacturers have submitted an application for an MDR certificate, that there are still something like 15,000 without even a submission. And then you have a look at the timeline, and the statistics are currently saying that 82% of the MDR certificates, including the quality management systems, require 13 to 18 months. And when you have in mind and you take into consideration that we already have November 2022, and the total deadline for the MDD certificates is May 2024, then we are already around 16 to 17 months. So this is why the current public discussion is very much about the expected lack of supply that we will have from May 2024 on. So what we are always saying, and the public discussion is always saying, the message is always get MDR ready when you are a manufacturer and you still market your device under the MDD. So this were the bad news. Now I try to show you what kind of maybe short-term solutions you can try to take into consideration. This is, for instance, you need a CE mark only to legally place your medical device on the market. Once this is done, it can still be made available. So the European legislator is saying, once it's on the market, it's legally placed on the market with an MDD CE mark, you can still make it available for another year. So what you can do shortly before your MDD certificate will expire, you can maybe sell it to your distributor. You can hand it over maybe to your customers. And what you can also do to benefit from this so-called warehousing deadline or sell-off period that applies until May 2025, according to the Commission Blue Guide. I have to mention that the Commission Blue Guide is a document from the Commission that gives guidance on the interpretation of the European product rules. And this has been renewed in June 2022. And you can firstly find that placing on the market can already been agreed or can already have taken place when you are in serious contract negotiations with one of your customers. So it's not only that you need an oral or written agreement, physical handover is not required. It's already when you start contract negotiations that you can consider your product being placed on the EU market. And this means when you want to buy another year, or if you want to maintain the marketability of your device, then you either sell it to one of your distributors. They can have it on stock and still make it available to the end customer until May 2025, or you even enter into contract negotiations. Another soft way, I call it, to place something on the market is that you hand it over to your third-party logistic provider, or in the terms of the Commission Blue Guide, you hand it over to the fulfillment service provider. And when they have released it for free circulation on the union market, according to the Blue Guide, this is already being considered as placed on the union market. So this is something where you can, when you the expiry of your MDD certificate is very close, you can maintain the marketability of your legacy devices. A second solution for running out of, if you're running out of your CE mark, is that you can apply for a marketing authorization as the national competent authority. I've just said that we don't have an FDA. We are working with notified bodies in the European Union. They are doing conformity assessment procedures and issuing EU declaration of conformity, and based on this you can CE mark your device, and it's marketable in the entire European Union. If you are not able to run through, let's say, a successful recertification, or you're not able to get an MDR certificate on short note, what you can do when there is a public interest that your medical device is available on the market, you can go to the National Competent Authority. In Germany, it's the BfArM, the Federal Institute for Drug and Medical Devices, and you can apply for an authorization. It's an administrative act, and they would allow you, the German competent authority, the BfArM, would allow you to place your medical device on the market for a certain period of time. You have to show that it lies within the public interest, and it's also crucial to maintain the patient health and safety. This is something that already exists for a few years. It has never been used until 2016, 17, and I think also 18. And currently, it's not common practice, of course, but it's a typical means for manufacturers who were not able to recertify their medical devices or not yet having obtained an MDR certificate. Then we see strong political initiatives from the member states and the leading industry association. In this case, it's SNITEM, the French Industry Association, and the BVMed. This is the German Industry Association. And they have a call to the European Commission. They are writing letters to the European Commission. They're approaching it. And they are saying we need to extend the transitional period for legacy devices. For the high-class medical devices, class 3, and also implantable medical devices of 2 years. So that would bring the deadline from May 2024 to May 2026. And for all the other devices, class 1, 2A, and 2B for additional 4 years. That would then maintain the marketability until 2028. Another claim from this political initiative is that the notification procedure for notified bodies should be shortened, and the warehousing deadline. So for legacy devices who are already placed on the market, they can still be made available until May 2025. This deadline should be abolished. And in my view, it is not unlikely that this political initiative will be successful, because an indication for that is that it's made, or this political initiative made it on the agenda of the EBSCO. EBSCO it's not an association, it's all the member states and the health ministers come together in this committee. It's a council, and they then give a recommendation to the European legislator what should be changed or not. So I believe there's at least a certain likability that this political initiative will become successful in the near future. So this very briefly on the MDR, EU MDR update. I'm now coming to an update on 2 further key markets that we have in Europe. That is the United Kingdom and also Switzerland. It's indeed an update when I made this slide. So, or let me go one step back. You all know UK is not part of the European Union anymore. This is the consequence that the MDR is not applicable anymore. So that also means that the CE marks, so under MDD and MDR, should not be accepted anymore from a very formal perspective. But certainly there is a very overriding public interest that CE-marked medical devices are still available in the UK. So the UK legislator and the MHRA found a solution where they have said, we will still, for a transitional period, accept CE marks, MDD or MDR, until June 2023. I just learned from a very dear client yesterday that this deadline has been extended to June 2024. So if you are in the possession of a valid CE mark, MDD or MDR, you can still place your product on the UK market until June 2024. The only additional burden that you will have, if you not have already fulfilled it, you need a UK authorized representative, or they call it a UK authorized person. And you also need to notify or register your devices when you place them on the UK market with the MHRA. Same requirements for the Swiss market. The Swiss, they have never been part of the European Union or the European Economic Area. What has happened with Switzerland? The Commission had a mutual recognition agreement with Switzerland, and they were not able, because of a political dispute between Switzerland and the Commission, to renew it at the date of application of the MDR. So there is no mutual recognition agreement anymore in place. So what did the Swiss legislator? They have amended their Swiss medical device regulation and are referring now to the medical device regulation. And in effect, the MDR is still applicable in Switzerland. And also CE marks are recognized, accepted to place your device on the Swiss market. What they have also introduced is the necessity, the requirement that you are appointing a Swiss authorized representative, and that you register your device with Swissmed before you place it on the market. So this is a very brief update on the new regulatory requirements and discussions that we have around the EU medical device regulation and also around UK and Switzerland. And I'm happy to hear if you have any questions. If not online, then I'm happy to, please.
Get more color as to what's. Can you provide more color as to what's the acceptable sort of data standard or clinical experience to get a device on the market?
Yeah, that's a very good question, and there is no guidance and no case law yet. So you are referring to the point that when you, if you want to obtain an MDR certificate, you also have to show performance data now. And this is something that is complete black box for us so far. We don't know it. I don't have any intelligence from our clients who already have an MDR certificate. So I can't really say what you need to submit that they accept the clinical benefit. So a positive impact on patient health. I don't know if one in the room would like to share this information with us if they already have an MDR certificate. But this is really something I would expect also that it would be handled differently depending on with which notified body you are working with. So yeah, that's something we still need to see, and the developments will be very interesting.
I can maybe speak to the.
Please.
Oh no, I was just going to provide it. It's chat. It's fine. It's to address the comment.
We have time.
Thank you.
Actually, Matab, if you want to, we have a little
Oh
extra
yeah, no,
time.
but he was chatting, so I was addressing his comment.
Please,
Go ahead.
Marta,
Yeah,
go ahead.
So we don't have an MDR
I'm curious.
certificate yet. We're in the middle of a very, what I would consider very simple software device, which was a 510(k) cleared product in the US, went through very easily. And we worked through BSI. They're getting very hung up on what is the clinical benefit of your software device. It measures volumes, it measures lung, it's focused on the lung. And I feel like they're really struggling positioning that clinical benefit, which I think in the past they would have looked at a clinical evaluation, given it a thumbs up, and it would have been done. But that's really where they're getting hung up. And I think they're looking also for more statistical rationales around your clinical data, whereas in the past you could have said, oh, we did a 20 patient study, the safety looks good, and performance was fine, you know, and they're really looking for more statistical rationales as well.
Thank you. So thank you very much. I'm now happy to hand over to the panel discussion, which will be led by Amanda. Thank you.
Thank you, Cord. Okay, Adam's going to mic up our panelists. I thought I would put you on the spot, Cord, quick. Does this have the hallmark of a potential crisis in Europe? I mean, you have this huge demand and not enough supply, and you have to do these things like buy the devices and put them in warehouses and play these tricks. Could this lead to a crisis? I mean, you know, the products save lives and keep people alive? What happens if they're not available?
Yeah. That's indeed a very good question, and this is why the public discussion is currently ongoing, and even political initiatives are carried out, because the numbers are speaking for themselves. We have 23,000 legacy devices who are still not MDR certificate, who do not have an MDR certificate, and we would not expect half of it, or maybe three quarter of it, having an MDR certificate in May 2024. So I think it's clear that the European legislator has to do something. They have to extend the deadlines, and otherwise I have also mentioned this national solution that you can obtain a marketing authorization from the national competent authority. I think that would otherwise be the way to fill this bottleneck or supply bottleneck. But it's really massive. We're running in a huge problem, and there must be a solution. And we are confident, or we are at least in strong hope, that the EBSCO Council that I've mentioned, that has a meeting in December, will find some solution that will then be addressed by the European legislator. We will see.
Thank you. Yeah, I mean, I think it sounds like they'll have to come up with a widespread solution, or else you're going to have medical tourism, and just terrible things could happen, right?
Yeah.
Well, I thank you very much again, Corey.
Thank you.
Appreciate it. I think we're just about ready to start. Everybody mic'd up? Yeah? All right, Amanda, take it away.
Hello, hello. Okay, there you go. All right, well, thanks everybody for sticking around. We'll save the best for last.
That was Freudian.
Least for, yeah, no, it's good. But yeah, no, we'll have a little fireside chat. We should have moved it out to the pool with some patio heaters around us, but we'll just pretend. But thank you guys. I'll introduce briefly our esteemed panelists. But yeah, and so we'll just have a little chat. If anybody has questions, we can kind of bring those up as well. Can you hear me? Okay. Yeah, oh, you have the mic, yes.
Got the mic
Yep.
as well, so I can, if you have a question, I'll bring it over to you.
Yeah, we'll try to talk about some of the topics today in a little bit more detail, just kind of with their experiences at companies. But yeah, feel free to, if you guys have any questions or ideas of discussion topics, feel free to let us know. All right, Alali, do you want to introduce yourself briefly?
Sure. Hi, everyone. I'm Alali Nuri. I'm the Chief Legal Officer at Procept Biorobotics. And Procept makes a robotic surgical device that uses highly pressurized water to resect tissue for the treatment of BPH. So that's in the prostate. So men's health device.
Thank you. Bill?
Hi, everybody. I'm Bill Revelos, and until very recently, I've just left the company, but I was the Vice President and General Counsel at Corvista Health, a company based out of Toronto and Washington, D.C., working on a cardiovascular diagnostic product to look at artificial intelligence and machine-learned solution for diagnosing heart disease. And right now, I'm the principal at Insight Legal Services.
All right, Mike?
Hi, my name is Mike Pisetsky. I'm General Counsel at SI Bone. We make orthopedic implants focused on what we call the sacropelvic solutions area.
Thanks, guys. I like that we have a good mix of technologies. All right, so we'll start with thinking back to my speech on park doctrine. Just want to get, if you have any thoughts, anything come to mind, anything that you think you might do differently going forward, or any thoughts?
You know, from a startup perspective, this I have to admit, this was something that I really wasn't on my radar. I don't know about you all, but especially in a startup perspective, you don't think about these things. And when you're trying to build a company, maybe you've hired your first quality person. You're just trying to build a quality system. You're trying to get your infrastructure in place. What I think your presentation gave me the feeling for is that you better be hiring people with high integrity and people that you
Yeah.
trust and that you really feel good
Experience,
about
yep.
working with. And that goes for your boss, the CEO, and you had said one of the directors, a director level
Yes.
person had been held liable. And so, that just shows to me that up and down the organization, and this goes for any kind of compliance program, but when you talk about that doctrine, how can you avoid it? If justice is coming and they're threatening problems with you, or threatening this misdemeanor prosecution, and you might go to jail, that horse has left the barn. You need to work at the very beginning to make sure that you trust the people you work with. And I would not touch with a 10-foot pole a company where I don't feel good about the people I work with.
Yeah,
Because what else are you going to do?
Yeah, that's a really good point. Yep. Anyone else? You don't feel obligated, but if you have any thoughts.
I didn't know a lot about the park doctrine until your presentation. I'm not going to lie. I was scared of the Yates memo, so at least I feel like something was on my radar.
See,
Right.
Yeah.
I was thinking during your presentation a lot about separation of duties. I know there was the example where he delegated the duty, but at least knowing who's going to do what.
Yeah.
And so with respect to my role, I review all the promotional materials and the marketing materials, and I was thinking about, well, I'm not the one validating and making sure the citations that are on that piece of paper support the statements that are being made. But it's very clear within our company who I expect to be checking all of that.
Yeah.
And make sure there's strength.
That's a really good point, especially outlining roles and responsibilities, who's in charge of what. I think that will help as well.
Make sure regulatory and quality don't report up through legal.
Yeah, yeah, there you go.
Exactly.
Another learning, good.
We also talked about, before we got up here, about looking at your indemnification provisions.
Oh yeah, yep.
Right? Certainly the CEO tends to get the indemnity provisions that are really good for that person, but it's made me think, well, you got to look at the rest of your executive team, even down to the director levels, and that may be a more interesting negotiation.
Yeah,
in the
absolutely. Now you're better armed for negotiating. Okay, we'll switch gears. And I don't know, we didn't really talk about this beforehand, but do you guys do business in Europe? And if so, what's your experience? Do you have any reaction to what Cord and Oliver shared about either privacy or MDR?
So we have multiple EU subsidiaries. It's been a real challenge. I think we're near the end of at least our MDR process for one product, but I think there's this real open question as to what the clinical experience or the data requirements are going to be for future products for us. It's the privacy is also a real challenge.
Yeah.
Fortunately, we have a product that's fairly simple from a privacy perspective, so we don't pass data back and forth. But even stuff as basic as HR data with our employees in Europe, it's a challenge. And the notified bodies, we've had to push to get the mind share that we need from our notified body.
Yeah, we have subsidiaries in Europe too, and Cord heard a lot from us several months back. A lot of phone calls, a lot of tapping into his expertise, but happy to say that we comply with MDR now, thanks to my team and Cord, and the regulatory team at our company. But it took a lot of back and forth with the notified bodies, and so.
Can you say how long it took, or no?
What do you want to say, 18 months, 2 years?
Okay. And that's pretty consistent, it sounds like. Interesting.
I don't know, Cord, from what you said, I think I want to start a notified body company.
I know. Yeah, maybe.
There's a pretty big demand there.
Yeah, that's true. You'll have job security for at least 5 years or something. Okay, and kind of along the similar lines with Mike, you mentioned privacy. Cybersecurity, it's a hot topic. Paul talked about it from an FDA perspective, but we also, you can think about it from a just privacy security internally. Do you guys does your company have cybersecurity risks? If so, what types of risks, or what are you doing to kind of mitigate risks from a cybersecurity perspective?
So even though we have a robot, thankfully today the robot's not connected to the network. So I feel like that's a little bit lower risk right now. I mean, I'm sure at some point in the future that I won't have the luxury of saying that. But I think cybersecurity is a risk everyone faces, and you know, in my experiences over the years, I've seen really smart people do things that they shouldn't do. I've had to help navigate situations where like accounts payable paid an invoice that was fake and it looked really real, and it, you know, former employee of a supplier went and created paper. Anyway, so, you know, I think you have to pay attention to cybersecurity in general. One thing our head of IT did recently, which we thought was very interesting, is he sent out a faux phishing email and tested to see how the company responded. And
I like that.
It was really surprising. It looked like a typical phishing email, and it prompted the employees to log in, you know, click here to change your Microsoft password.
Oh dear.
And it was really surprising how many people clicked and how many people tried to change their password.
I really like that idea.
Yeah, and it was simple. He didn't hire a third-party firm. They just
doesn't cost
created an
anything.
email, and then he presented it to the company and said, people.
What did everybody say? Oh my,
Yeah.
That's a good way to learn.
Well, I'll give you a real life example. The company before my last one, there was a real life phishing attack, and I'm sure you all have been in these situations, but it was around tax time, and someone from the outside was posing as someone in the finance department, sent an email to the CFO, hey, can you give me access to the network? We got to get the W-2s ready for the tax returns. Sure, here it is. Here's the password.
Oh, jeez, yeah.
All of the Social Security numbers for 300 people went out, and most of our identities were stolen. And I'm still dealing with that. So, you know, and I think it's important, you know, what Paul was talking about on cybersecurity is, you know, in the device context. And, you know, if you have a device that happens like my last company, Corvista Health, it has a lot of cybersecurity risks. It's a software as a service diagnostic. It's all in the cloud. And so we're thinking about product-related cybersecurity, but there's this corporate side too that everybody has to deal with, right? And it just makes it dizzying. We were very lucky at our company when I came on board at Corvista Health. They had a chief information security officer, a CISO, and boy, I learned a lot from him. And it was fantastic to be able to, you know, work together, and there's a privacy angle to that whole thing. And you know, the product is still not on the market, but there's a lot of work to be done, and I think that's key, is to have some talented people in place.
How do you?
Mike, sorry, the audience online.
Oh, they can't hear you.
Yeah, loud and proud.
Hold it up.
Thank you.
I'm curious for you guys, where's the reporting for cyber, privacy, legal, how organizationally, how do you line it up?
Right, the CISO reported to me, and I reported to the CEO. And then we had a VP of regulatory. We didn't have anybody privacy, no title for a privacy person, but so guess what?
Yeah.
I had the privacy
Lucky
responsibility as well. And you know, it's a very small company. There are 40, 50 people. So you know, that org chart aspect of it, and as your compliance program evolves, I think that you have to be very careful looking at the org chart. Because I know what you're asking about. I mean, that's it's incredibly important to have good reporting lines and backups.
Yeah, I mean, we get the question. We get intense scrutiny of this at the board level. I mean, luckily on the product side, we sell titanium rods. So it's pretty basic, but you know, the corporate side of it, and you know, we've had luckily nothing big, but small scale phishing attacks, and you know, it's the focus of it's subject of a lot of energy for us, and you know, legal working together with IT. And reporting every quarter to the audit committee and so forth.
One thing that I learned a lot in understanding how information security and cybersecurity works in that context is that you really have so much planning to do before you launch a product, and it really pays to invest in the infrastructure to work on that SOC 2 compliance, to do penetration testing, to look at your vendors to make sure that they're done. Even establishing contacts or relationships with law enforcement in case there's a problem, and get a relationship with them in advance. And the whole thing that Paul was talking about with the FDA guidance and really designing cyber security into your product, it's huge. And our CEO is very supportive of that. But if
Yeah.
you don't have the budget and,
Yeah,
and you don't have the
exactly.
attention, it
Then
can
it's
be
an
a challenge.
afterthought and you're scrambling, yeah, for
Right.
submission at least. Yeah, we had, even at the firm, we've had phishing attempts where they'll text or email us and be like, hey, it's Tracy, can you go pick me up some gift cards?
Yeah.
And we all mess with them, but yeah, it's crazy. Yeah, I do your companies do, so I like the idea of the fake phishing email. Is there like training or reminders on kind of what phishing is, what hacking is, like that kind of thing too?
So we actually have a system or software that does the simulated phishing attacks.
Okay.
So all our employees regularly get kind of simulated phish emails.
Yeah.
And then they have to identify them right
Okay.
in Outlook. And then if you miss one, it takes you to a training.
Oh,
So,
okay.
yeah.
It's kind of cool. I've never heard of something like
So
that.
yeah, we have the online training that's annual, and then I think the people that clicked on this email are all going to
Oh,
get
sure.
supplementary.
Yeah, they have to go to a boot camp on
Yeah.
phishing. Oh, that's funny. All right, we'll switch gears. A couple of the poll questions we asked about clinical trials and enrolling and also pre-market products. And I think we have a pretty big percentage of the audience that has pre-market, they haven't yet commercialized. So would like to get your guys' thoughts. Any lessons learned that you could share related to kind of getting into the commercialization phase? Anything you wish you would have known? Just any tidbits to share? Or war stories?
Everybody's looking at me. Yeah.
Somebody else want to go?
Okay, well, I've been in several startups, and the getting regulatory approval for your first product has been, unfortunately for me, a very difficult thing. And when the economic climate shifts and you're in a fundraising mode, and then you're going sideways with the FDA, that can be difficult. So that's what I've recently experienced. And in the artificial intelligence, machine learning, software as a service context, we talked about this earlier. I think FDA is still trying to figure it out. I was looking, and I saw no less than 5 or 6 recent initiatives over the last 3 years, guidances, pilot programs, et cetera, that FDA has put out. We can have a great piece of software with a great validation plan. We've got all the statistical analyses. We've hired the right consultants to test it 10 ways to Sunday. And you get it in front of the FDA, you put a 5,000-page package in front of them, and they say, this looks great. And then, later they'll tell you something completely different. And my sense is, and I don't have any evidence of this, but they're still trying to figure it out as well.
Yeah.
And they may be happy, the individual reviewers may be happy with what you submit, but by the same token, they're looking at the industry and they're trying to have uniformity with the way they deal with the industry. Right. And so maybe sometimes the answers you get are not because of what you're doing, but it's because they're still trying to figure it out.
Right, and time passes between, they're shifting, they're learning too. So yeah, I can imagine that's a challenge for sure from a reg perspective.
Right.
You want to go, Mike? Or should I?
Yeah, go ahead.
Hold your mic.
Go ahead.
So, couple things, I guess, obviously having your compliance program in place and getting your basic policies, just thinking proactively about that. Even further back, if you have a implantable product or a high-priced product or a new procedure, you want to think proactively about clinical, regulatory, and reimbursement, all three together. So, you can find you do the right studies to get through FDA, and then the payers want something different.
Yeah.
Right. So that can be a big issue. And then the final thing I'd say is you can think carefully about kind of international, because sometimes your commercial team sees it as an easy win, but it's a high workload for it's typically just less kind of payoff than the U.S. And guess where the workload falls?
Yeah. Well, and it used to be the case that you would always go to Europe first because it was faster and easier, and so now it's kind of shifting.
I was going to say something similar about the reimbursement. I think making sure that at the beginning of commercialization, you're really thinking through your long-term reimbursement plan at the same time is really important. And a lot of times folks don't have internal people, so getting the right consultants, because the pricing decisions and the clinical decisions that you make will affect the company for years to come. That's something that I
Making
learned.
sure you have a good publication plan and you're getting the right data out of your studies and getting papers out there in the literature that will help build your case for reimbursement
Yeah.
depending on the coding
That's a
you're
really
looking
good
for.
point.
There are a lot of consultants, and there are good ones, and
Yeah.
there are less good
Yeah.
ones.
Yeah.
Agreed.
And a lot of times, some of what the consultants sell is sort of access to payers.
Yeah.
And,
Yes.
very kind of questionable results.
And then just to be fully honest, I mean, a lot of times in the early commercialization stage, sales and marketing folks come to you and say, everybody does blah. I mean, we've all heard it. Everybody does. Why are you opposed to doing
Yeah.
this?
Right.
It's often the case that everybody does not do what they are suggesting. So just be wary of that. And right-sizing the compliance program, I think, is important relative to the stage of the company. You can't do what a very large organization does, but you still have to have a program and still be mindful of the laws and the regulations and question what they are suggesting. I still call, Mark or Amanda sometimes and say, I'm being told that this is very common. I've never seen this.
Yeah, we get those questions like at least once a week. So
We had a fun one recently where the marketing person said, well, Coloplast is doing this, and Medtronic's doing this, and some other company we'd never heard of. And I'm like, well, let's get Lisa and Amanda on the phone, because Amanda ran compliance at Coloplast. Lisa was in the
just
legal
did it.
department. Amanda also worked at Medtronic, and they were kind of like, oh, dang.
we're like, yeah, no, that wasn't
Sometimes
gonna
we'll say even, not to be a lawyerly, but we call that hearsay.
Yeah.
Someone his brother-in-law
Yeah.
did this. We don't know if a lawyer ever looked
Well,
at
right,
it.
exactly. That's the
So
half of the story. Yeah.
We get that literally every day.
Yeah.
Can I ask a quick question about the compliance program? You brought that up. Mark and his team were getting ready to help us put ours together. And I find that a daunting process in some respects. I was wondering if you two could maybe, talk a little bit about that. Did you build the compliance program in your company from scratch, or did you come into it later?
No, I mean, I came into a relatively developed compliance program, but we've kind of iterated and built on it. I think, is there a pretty basic kind of standard or a basic package of policies that you can
Yes.
implement? You put together a compliance committee, a grant committee, if you do grants, and then just some basic education, I think is those things get you a good start.
Yeah, I mean, for people looking at reviewing this video in posterity that aren't here, I mean, it's like take the AdMed code and that's your P&Ps and build things out of that if you're just trying to do it really efficiently. Of course, we have pretty much any policy or procedure you can think of. It's always best to try and take something that is already exists because it's just more efficient. There's a lot that companies even put online. So there's ways you can find all kinds of good stuff. But to me, it's we always talk with clients. There's like a core group of policies and procedures that we recommend, and from there, it's just a matter of what your business demands are.
And I think what we've done, we start with the kind of core policies, but then in our compliance committee, when a business person raises an issue, we'll go off and sort of study it and come back at the next compliance committee and talk about whatever we learned, but then iterate on the policy. And I think that buys some credibility with the business that you're being flexible and you're looking at what the market practices are and you're calibrating accordingly.
Right. Yep.
But
I don't know. Is my yeah? It is.
Yeah.
Okay. Thought it went
we
out.
didn't have a program, so we built it over time. That's, I think, an uncomfortable period where you need 6
Yeah.
different programs and you don't have the resources to put in
Yeah.
place
Right.
6 different
Exactly.
programs. So you just have to prioritize and do it over time.
Okay.
Yeah, I mean, we have clients that come to us and they want to put everything in place at once. And it's like, that really is not a good idea, because not only is no one going to read any of the policies that you put into place, it's just information overload. So it is, kind of little at a time is probably best. Okay.
We have an online question.
Oh.
It's really long.
Okay. Can you simplify?
Since cybersecurity affects so many, if not all, areas of a company, are there recommendations on organizational structure to address this? In my experience, there are silos between device development, privacy compliance, production equipment, finance, HR, and so on. So just to recap, are there recommendations on organizational structure to address the many different
Right, because
groups?
cybersecurity like spans so many different,
I wonder if they have a CISO. That would be one thing that has authority, that reports to the CEO and has authority across the different functions, to deal with it, because it is a ubiquitous issue.
And CISO stands for?
Chief Information Security Officer, and I think that's to be distinguished from your chief IT person.
Right, yeah.
Who's getting laptops provisioned and making sure that the things are plugged in properly. But that job, I think I'm going to tell my two boys.
Yeah, go for that.
Besides opening a notified
That's
body,
a good point.
it'd be an information security officer.
Yeah.
I think depending on the size of company, many companies don't have CISOs, and then I think that becomes a problem. Is it the IT organization? Is it the product R&D organization that deals with the security risk on the product, depending on the nature of the product? I don't have a good answer for it. I mean, I think I've seen multiple companies struggle with how to structure that responsibility.
I think if you think about the economic threat that cybersecurity poses and how the whole company can go down with one phishing attack, it's an economic thing where you just say, well, look, we've got to devote in our HR budget, we've got to hire people to deal with this because we're protecting our assets, we're protecting our business model, and it's 2022. We've got to live in the present.
No, that's a really good point. Yeah, invest where the risk is. I've seen some clients do like a cybersecurity subcommittee of the compliance committee or privacy subcommittee that kind of reports up. But yeah, I'm sure there's probably lots of different ways, but I like the CISO idea and having reporting structure.
I think also getting regular board communication, or the audit committee, typically. And then once it should almost be a quarterly item for the audit committee, and if they're attentive, if you have a good audit committee, they will make sure there's budget for it. Make sure you're doing the right thing.
And it helps to have a product that is that's a cyber type product, like a diagnostic product like ours. One of the things that I learned, they're not on the market yet, but you're going to go to the first person you're going to talk to at a potential hospital customer with a product like ours is the Chief Information Security Officer of the hospital.
Yes. You'll
and
get
the person who's in charge of the network. Are you going to be using our network to what Paul said?
Yes.
Okay, well, I've got to take a look at your system and your device, and are you SOC 2 or SOC 2 Type 2, Type 3? If you're going to work with a VA, they've got entirely different, the NIST level of information security requirements. They've got some of the most stringent requirements as well, and VA is a massive market for some medical devices, and if you want to work with them. So you really have to be thinking in advance, as you're building the product with that in mind, and there'll be nothing to get board attention more than when you're talking about, well, how am I going to make money with this product? And the initial gatekeeper is the CISO, the hospital. Okay, well, how are we addressing that? Right.
The other thing you can do from an organizational perspective is get audited. You bring in an outside group, and they do the NIST audit, they do a HIPAA audit, and depending on what the results show, you can draw attention to problems that way.
Right.
Yep. Okay. Are there any other questions online? No? Okay. I have one more question. What keeps you guys up at night? Now, you don't have to give a specific example, but just generally, I'm curious where kind of your head's at these days.
Potential salespeople.
Yeah. What salespeople, just what they're doing or what they're not doing?
And education, right? If you have a field sales force, they're just out there. You have. How do you stay connected with them? How do you get insight as to what they're doing, what they're saying, educating them, being in sort of regular touch with them?
One of the things I learned to do at a prior company was I was appalled that how many times I had done live training and then later realized that they really didn't remember or understand any of what I trained them on. So I started giving gifts in my training sessions. So you know how you had these questions? I would
Throw out
ask for
candy or
volunteers.
something?
No, I mean, I'd give them like $50 gift cards or like
that
a
would
nice,
get you
like a
learning.
nice
Yeah.
mug. And they loved to make fun of me and say, you're bribing us and you're teaching us about anti-kickback. I said, that you're not an HCP, you're my employee. So
I like that idea.
I think it helped in terms of making it more interactive and engaging them in the discussion and the participation. I don't know that it helped them remember when they left what we discussed, but I'm hopeful that it does.
Yeah.
But that doesn't answer your question about what keeps me up
No,
at
that's
night.
I'm not a member of the panel, but I just add
What keeps you
one thing on that. I've had CEOs come, one in particular that I think the Salesforce kept him up at night, and he said, Mark, I want you to create all of the rules from the training, put them on one page, and then I want it to say essentially that the employee may be fired if they violate the rules, and I want them to sign it, and their bosses have to collect it all and keep it in their file. And I was like, okay. So I've had a couple CEOs since then that like that idea. That's another way. It's a little bit more heavy-handed, but I know this CEO felt that Park Doctrine type of exposure, and they were getting this close to being bought. And he's just like, I'm not letting anything mess this up. Another thing is if you're using Viva or whatever it may be for your training, we all have to take these trainings, I bet, where there's quiz questions. So, okay, review this complaint handling procedure or whatever, and then you can throw some questions in there. Of course, the sales reps are probably telling each other the answers. But I did experience this firsthand as well as a product manager where there's 180 people in the field that I had to send a message to once a week. And I learned how difficult it was to get their attention, even to open an email, let alone read what's in the email. So another thing that we've done in that, or what I've done since then, is I'll have the sales leader, if the team is doing something wrong, I don't recommend that the GC or the compliance officer always be the one that sends the email out. Have that boss of all of those commercial folks send it out, and implore in that individual how you want everybody to take this very seriously. And the good sales and marketing people they'll answer that call. And sometimes we'll have a requirement for each rep that they have to write back to their boss that they read and understood the message. So just a couple thoughts for you.
I think in the startup context, what would keep me up at night is what you alluded to is, oh, I've got so much stuff to do, and we're hoping to launch by X and such date. And how am I going to do this? I'm a department of one, and I've got a limited budget. That's tough, but everybody's got that. You don't have to be the GC to have to deal with that. But sometimes it's hard in a startup context because you're limited.
Sure.
Yeah.
Yep. Did you answer what keeps you up at night?
Come on.
So I don't ever want to be in a position where the company wants to be on the cutting edge of something really exciting, and I don't know how to help them through that. And it sounds like that's what Bill actually had, which is, I'm worried like the future will hold AI and a lot of intelligence, and it's the cutting edge of the law. I kind of dread when and if I'm ever in a position where that could happen. And because, right now I feel like there's good people that I can, call on for experience for things that have already occurred. There's really good resources out there. But for something that's on the cutting edge, I think that's really hard.
Yeah. No, that's a really good point.
Even the FDA doesn't know how to handle it.
No, I know.
Well, yeah, I mean, that's the thing about the startups. I've always been attracted to that. Like, oh my gosh, I was with Zeltic Aesthetics, the cool sculpting people.
Oh, yeah.
Were bought by Allergan. And no, I left before they were bought by Allergan. But, we were going sideways with FDA on that.
Yeah.
They didn't know what to do with us. It was so new, and the safety profile was great. Certain exceptions aside these days, but you can't convince the FDA because they don't know what to do with it, and that was difficult. That kept me up at night. But we chose to be in that company.
Yeah. I mean, it's
ultimately was
exciting, but
successful.
that's
High
scary
risk,
and
high payoff,
challenging
right?
at the same
exciting,
time.
and you want to help them.
Yes, absolutely.
And then you got FDA approval?
Yes, got FDA approval and went through an IPO and ultimately was acquired. Very successful company. But we were going through the Great Recession in 2008, 2009. All of our board members had psychiatrist couches that they were laying on during our board meetings. Their Rolodexes of their hedge funds were gone. And we couldn't raise any money. And FDA kept telling us one thing one day, and the next thing they tell us something else.
That's frustrating.
And we didn't know what to do and ended up laying off a large number of people before they ultimately got FDA approval. So, the regulatory stuff, if you live in this world long enough, you realize it can control your destiny.
I have a question. So, we kicked off with this park doctrine, right? And, how afraid people should be and not to break the rules. And I want to understand the cybersecurity and the implications of being very afraid. Or is it still, something that we need to do because it's a good idea? Or is there some sort of penalty for the companies who would not be implementing cybersecurity measures?
Do you mean the cybersecurity guidelines from the FDA?
Yeah, for example.
It's sort of like the intersection with maybe criminal misdemeanor liability under PARC for that. Yeah, that's a good question.
We have rules and regulatory that we follow because we want to get our product approved or cleared or whatnot.
Yeah.
We are going to include risk assessment related to that, but ultimately these are kind of the processes that are specific to product development, if you will, but they're not criminal. And so I'm trying to understand, you guys are all lawyers, is there something outside of
I could see it being a misbranding violation if you're having adequate cybersecurity.
Does the panel
False
want to
Claims
take that
Act.
question, or should we call phone a friend?
Yeah, I was going to say, Paul might be best suited
It's
to
technical.
answer
It's too
that.
technical for me. That's when I would call Mark.
Well, it seems like, it
Paul.
does seem like you have to think about that. From what Amanda's presentation I learned, there have been a handful of prosecutions under the PARC doctrine or maybe implied in the prosecution. In those fact patterns that I saw, it seemed like the companies were doing something wrong.
Yeah.
You could tell there was something bad going on. If there was ignorance on the executive's part, they should have known. They didn't have the right controls in place and everything. And cyber is just part of that now. It's part of the design for certain products.
For sure.
It's a corporate thing as well. So to me, we're living in a world where I think that's inevitably going to be part of it. And I think Justice and others are going to be considering that among the other menu items when it looks to whether or not you've been doing the right thing. That's just my opinion, but.
Lale or Mike, did you want to? I could have.
I'd like to phone a friend.
Paul can talk a little bit about the FCA, the False Claims Act, and whether there's the implied certification theory, and whether a manufacturer could somehow induce a false claim. I'll leave that to Paul.
Paul's like,
Yeah, just to add to, that's very loud. Just to add to that discussion, I think I did some research to see, is there currently or has there been any enforcement for cybersecurity failings in a medical device that leads to criminal liability or any? There's nothing like that I'm aware of. I certainly, as Amanda said, could see, you design, say, a software medical device and don't address cybersecurity at all, or misrepresent the development of that device or in some way. Yeah, certainly. I think that goes, though, to Bill's point, if it's obviously bad conduct. I mean, that's going to definitely, whether it's cybersecurity or anything else, the FDA is worried about safety and effectiveness of the device, not cybersecurity specifically. So those things together, I think lead to the possibility of that.
And you may do everything you can to get that FDA approval for a device that's got a lot of cybersecurity considerations, and you've passed that test.
Yeah.
But what about 2 years down the line? Every day is a new day in the world of cybersecurity, right? There are new challenges, there are new types of attacks. I hear a lot about zero trust principles these days, and how that's a big trend for many company IT departments and CISOs, that you have to be able to trust no one, and that takes time and money. So it's not just after you get approved, but you've really got to think about it for the life cycle of the product in the company.
I
guess I may be a little cavalier here, but when you talk about the Eighth Memo, the Park Doctrine, and I look at all the cases, I tend to think that like Bill said, these are cases, and it may not even be obvious from the release, but they're cases where there's some element of really bad behavior, right? If it's simple negligence, yes, maybe they get a corporate settlement in those kind of cases, but it's interesting to look how many of them are opioid related, just off the bat. So DOJ is clearly kind of picking and choosing where they wield the kind of heavy.
They have limited resources, so they have to be selective, and they have to choose cases they think they can win.
Yeah.
Right.
Do you ever wonder when you read the case summaries or the articles if it's really as bad as they describe?
Yeah.
That's actually something that keeps me up at night.
Like the complaints and the settlements.
What if it wasn't as bad as they make it sound, and they're taking it and putting in that light and
that's
really?
So true, though.
I think that's real too.
It's always biased, I feel like, yeah.
We were talking about the case that comes to my mind is this Abiomed case, right? Where they investigated for years and years and finally settled for $3 million.
For the meals, you
mean?
Yeah, for meals, yep.
And it was 1.5% of their meals were over the limit. So
something there.
They couldn't point to anything else, but again, no criminal prosecution of the execs in that case.
Yeah.
But they have to leave with some settlement.
I think that's right too. Yeah.
I can't resist chiming in really quickly. So I'm going through my head and saying, how can I sterilize what I'm about to say enough? Because I have a friend who's a federal judge, and she was involved in a case and shared firsthand that the facts and what you read in the complaint really didn't match up with, and it's the classic, you're only hearing one side of the story.
Yeah, exactly.
And at home, with the kids, if they're fighting, they're like 17 and 18 now, so they're not fighting anymore, luckily. But if you're hearing from one, you're not getting the other side, and you hear the other side, and you're like, okay, you both are going to timeout. But I could say also there was a case involving EB3 some years ago when I worked there, and because Amanda and I and others in the firm will tear complaints apart and read these they're kind of fun to read actually. Sometimes some of the facts are really pretty wild.
Yes.
But in that case, they were claiming that there was off-label promotion, and that without getting into the facts, it involved an atherectomy device, and if a stent strut got in the way of the cutter, you shouldn't be using it in a stent ever. But if somehow the physician got hung up on one, there was a way in which they could reverse the device so you wouldn't have to send the patient in for an open procedure, and they could, die. And the FDA took that the reps having that knowledge as off-label promotion, that they were trained internally on that, how to reverse it, that was off-label promotion. I was like, that's not off-label promotion. That's the company being responsible, knowing that if someone misuses your device, that patient safety could be, in peril, and the patient could die. So I could say, back to that comment, I do think that you're definitely getting one side of the story, and a lot of that stuff is they're just whatever they could throw at the wall. Which we would all do if we were prosecutors. You would probably be coming up with every theory you could to try and get the other side to settle.
Yep. Okay. Well, thank you guys so much.
Yeah, thank you for having us.
Panelists. Really appreciate it. And that wraps up our program. So thank you for coming. And I do want to give a special thank you to Tracy and Karen and the back office help for making this possible. And our AV guys and our audiovisual team who awesome.
Thank you.
We definitely couldn't do it without them. But thank you guys for coming. Really appreciate it. Really enjoyed having all this face-to-face time. It was great to see you all. So thank you. Have a good evening.
Thank you, Amanda.
Yes.